Mention করবেন?
My lord, in very, very compelling circumstances, one matter, my lord, appearing as item number 749, though it is appearing under the heading upgradation motion. But what happened, my lord, pursuant an order passed by this honorable court, compensation money has been sent by the central authority to the Farakka Barrage Authority, and money is lying last 1.5 years. Now, my lord, the authority only want a clarification that in what way they will disburse the money.
What is the urgency?
Urgency, my lord, is there's the petitioners. There are 13 petitioners, my lord. More than 6 or 7 petitioners' father are suffering. My lord, they cannot treat their fathers for, my lord, for,
You have to wait for some time.
my lord. Kindly,
Restoration applications and fresh contempt applications. That's all, nothing else. Please wait for some time. Restoration. Urgency will be considered later on. It will be considered. Please wait for some time. Yes, no. Restoration upon notice. Yes. Are you mentioning upon notice? It's a restoration application. Please mention upon notice. Yes, call the case list, please.
My lord. Item 57, my lord. One can application I have filed, my lord. Liberty to amend the cost item, madam.
Yes.
Liberty to amend the cost item, my lord.
Which matter?
Item 57, madam.
Let it be called, sir.
Your lordship, may I permit to mention for upgradation?
Please see the first page of my list before you mention. Yes, what is the correction
My
required?
lord, kindly able to come second paragraph of the order
Who is
dated
appearing?
20th
Who is
February.
appearing?
My lord, the primary grievance of the petitioner is that buses, including that of the private estate, are flying from Sonarpur to Bagna. It will be, my lord, Ghatokpukur to Shyambaza.
Have you served the other side?
My lord, upon service I mentioned them.
Mr. Debra is appearing.
Upon service I mentioned them.
Please come at 2 p.m. It's a group 7 matter. Let Mr.
My
Debra be present.
My lord.
দিদি একটু দ্রুত সময় রাখুন।
এটা ঘটকপুকুর নয়, ঘটকপুর।
It is also abandoned in my petition.
Let him come. It's a group 7 matter. Please come at 2.
বলে ফেল।
Next. Your name is not mentioned. You were there?
Yes, she was there.
She was there.
At the time, yes.
This is embarrassing for me. Which order? A February 29 order?
My lord, WPA 442.
আর order date
31st January.
31st January order.
Well, after that, my lord. Last one, my lord.
Last order. Inadvertent error has crept into the order passed on February 29, 2024. In the cause title of the order, the name of Ms. Monica Roy be recorded as learned counsel for the learned counsel appearing for the NHA. Paragraph, the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on February 29, 2024. Next. Next.
My lord, inadvertently in the cost title, it has been recorded as state of Assam, my lord. Should be state of West Bengal.
Oh. The cause title, it is for the state.
The state of Assam in the order, my lord. In the order, my lord.
It is state of Assam. Oh, it will be. আসামেটার পরে আপনারই করে এটার পরে বোধহয় এটা হয়েছে inadvertent error has crept into the order passed on 20th February 2024. Paragraph, in the cause title of the order, the state of Assam and others, এটা inverted comma রাখুন, be read as the state of West Bengal and others.
My lord.
এটা inverted comma রাখুন. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order is treated as part of the order passed on 20th February 2020.
My lord.
Next. Item 4.
My lord, in the item 4, my lord, it has been incorporated as BSc RAL. It should be BSc RAIL. RAIL.
Inadvertent error has crept into the order passed on 20th February 2024. Paragraph in the cause title of the order, M/S Messrs. BSERAL, inverted comma around, Messrs. Be read as Messrs. BSERAIL. Inverted comma. The department is directed or the villain head? Item 5.
Lord, I appear for the claim.
Yes,
Yeah, for the petitioner lordship, it is that matter lordship which was pending for.
restoration.
Yes, lordship
Restoration and condonation.
restoration and condonation. Condonation of delay of 645 days.
Was adjourned on prayer of the KMD. On the
Yes.
earlier, or maybe you were not there.
On my prayer.
Yes, it was adjourned on your breast. Because they received the copy a day before lordship. This is the reason why it was adjourned.
Can 3 and can 2, isn't it?
Can
Can-
3 and can 2.
Can
Can
two,
3 is for condonation of delay and can 2 is for restoration.
Lordship will consider this can 3, the condonation of delay, unless the delay is condoned, question of restoration doesn't arise. If your Lordship finds, even if we have not used affidavit, but the Honorable Court can appreciate the explanation given in the application, whether there is any explanation to condone this huge delay, more than 640 days delay. If there is any such explanation, which can be considered as reasonable and sufficient for condoning the delay.
It is the lawyer's fault. They admit.
Lawyer's fault, my lord, whether that can also be considered as, if your lordship considers the can 3,
Yes, can 3.
2 and 3,
Yes.
2 and 3. After the petitioner was aware of the order passed in some other matters, then the representation, lordship, then lordship kindly come to paragraph 4. Then they contact it. This is the explanation only of.
On this ground itself, lordship, I was apprising my lordship of a judgment of Honorable Supreme Court. That what the Supreme Court's view is, lordship, when an advocate does not appear in a matter.
The party cannot be made to suffer, right?
The party cannot be made to suffer, lordship.
That's
This
right
is-
law. That is settled law.
This is, I want to, lordship, because I want to fight it out on merits, lordship. This is what I all can apprise, lordship. Because the previous lawyer, lordship, good, bad, indifferent, lordship, I don't know, he didn't appear, lordship. And the matter got dismissed for
Mr.
default.
Taluka, please fight it out on merits.
Lordship, kindly record my
I'll record your objection.
objection.
Yes. Yes, Mr. Butterbell?
Yes. Is a delay of more than 640 days, my lord? Your lordship, up to your lordship.
Objection.
Sir, I am
Record
not
our
gonna
objection.
give my consent, my lord, because there is no huge delay.
No
there is
question of consent. I'll pass an order.
Yes.
Again, can 3 korun. Can 3 of 2024. The petitioner prays for condonation of delay in filing the restoration application. Paragraph, learned counsel for the petitioner submits that the erstwhile learned counsel, who was entrusted with the responsibility of looking after the writ petition, did not inform the petitioner about the dismissal of the writ petition, and it was only after such information was gathered by the petitioner that the petitioner took necessary steps for appointment of a new learned counsel and filing the restoration application. Paragraph, learned counsel for the respondents raise counsels for the respondents raise objection against the said application. Paragraph. In my considered view, comma, no, educating, paragraph, the petitioner states that he was not aware of the dismissal since the same was not informed to him by his learned counsel. Stop. It is trite law that the litigant cannot be made to suffer for fault on the part of the learned counsel. Paragraph, the ground expressed by the petitioner being sufficient, comma, the delay in filing the condemnation application is condoned. Paragraph, there shall however be no redress to costs. Can 3 of 2024 is disposed of. Can 2 of 2024. This is an application for restoration of the petition, which was dismissed for default by an order passed on 11th May 2022. Paragraph, sufficient grounds being made out, comma, the petition, the order passed on sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 11th May 2022 is set aside. Paragraph, the petition is restored to its original file and number. Paragraph, there shall however be no redress to costs. Can such and such is disposed of. What about the writ petition? Can we deal with it here and now?
Yes, Lordship can deal with it, Lordship, because
Writ petition along with can 1, that is old can 8037, were to be heard together. That was the direction on earlier occasion on 3rd March 2011.
There was a direction for affidavits, sir.
Affidavits are complete. Yes, my lord may.
Appear as a hearing matter.
Yes, my lord may.
time for hearing, Lordship, it will
Time not possible. I'll fix a date.
My lord, may I file my oppositions? I have served opposition to the main writ petition and as also to the can 1, that is old can 8037.
Your opposition is
My
on
lord, I
record.
do not know because we have been, my lord, briefed on 2024, my lord. This is old matter.
Is
whether-
this a group 1 matter?
Group 1 matter.
Group 1 matter. Group
In that case, I have to release the matter.
Yes,
2009 matter.
2009 matter, yes.
This court can take up matters from 2017, not prior to
2009. In that event, that restoration application also.
that. Because it's my order. No difficulties.
Not,
You cannot go to before another court with a dismissed writ application, isn't it?
oh.
WPA the order code.
Lordship is releasing the matter, Lordship.
I have to release. I do not have determination. I have determination from 2017, not
7.
prior to that. Paragraph, since
Go to
WPA,
654.
WPA plus can code, since the matter since the writ petition was filed in 2009, comma, the matter be released due to lack of determination.
Lordship, and direction to the effect that let it be placed
It
before.
will be done within 24 hours. That's the standing instruction of the Honorable Chief Justice.
Yes.
This is not the mentioning time, madam. I'm sorry. Item number 6.
Please, your lordship, my lord,
Of the state, your lordship. Let me say.
for restoration of my writ petition, which was dismissed, my lord, on 12th of February, my lord. Sorry, 5th of February, my lord. This is well within time. Lord, may I file my affidavit of service?
Let it be restored. Fight it out on minutes.
My lord, only one indulgence, my lord. These pleadings are complete in the matter. If your lordship be kind, it's a hearing matter. If your lordship be kind enough to fix a date so that the hearing.
Can 1 and can 2, why both?
My lord, my lord, this has come as an NOC brief, my lord, from the. This is a change brief which I have received, my lord.
Can to not mean.
Look, can 1, can 2, even my client could not have.
There's a can 3 also.
The can 3 is my application for restoration. My lord, this is
Such a thick restoration application.
My lord,
His annex.
Lordships can
Have
one,
annexed.
can to already dispose your lordships. Page
1 and 2 are disposed.
158, yes, yes.
So you have no objection to this?
No, your lords.
Can 3 of 2024, affidavit of service. This is an application for restoration of the writ petition, which was dismissed for default by an order passed on 5th February 2024. Paragraph sufficient grounds being made out. The application is allowed. Paragraph the order passed on 5th February 2024 is set aside. Paragraph the writ petition is restored to its original file and number. Can succeed number. There shall have been no rest clause.
My lord, the earlier order may be
Disposed of.
revived, my lord. The earlier order, there is an order of stay. In nature of a stay, my lord, they have given an undertaking which will appear at page 140. My lord, no coercive measures will be taken in furtherance to the letter. My lord, order date is 24th of October 2019, my lord.
2019.
24th of October 2019, and after therefore, my lord, at page 142, order dated 8th of November 2019.
But lordships only for restorations. 5th February
Obviously saying
2024, your lordships for
that they have
application.
given an undertaking that no
Only
coercive
restore.
measures will be taken so far as the my lord, impugn notice
Whether
was
any
November 8, 2019.
29.
The last extension.
My lord, the last extension, my lord.
I do not find any extension at all.
But there is one extension at page 144. And thereafter, possibly that order has not been extended. Subject to correction.
Well, the pleadings were completed, my lord. This is not a order of stay, my lord. This is an undertaking which they have given.
When was it extended?
My lord, last
Page 144, it was
What-
extended till 13th of December 2019.
2019.
2019.
We are in
Subject to correction
2024
by
now.
matter.
My lord, thereafter
No
the
question
matter,
of-
my lord, thereafter the matter was heard all throughout, my lord.
Maybe, but there is no question of extension of
My
an order.
only
that
request is
existed.
they have given a undertaking that no coercive measures will be taken, my lord. I'm
The
only
order has met its natural death in 2019. So how can it be extended now? I'll fix a date for hearing. And
No,
nothing has happened since 2019.
no, my lord. My lord, that is the only assurance which I'm seeking before this honorable court, my lord.
Sure.
An early date may be fixed, my lord. For you.
WPA the order. Let the matter appear under the heading Group 1 hearing.
My lord,
Group 1 hearing.
group 1 here.
Group 1. Hearing on
নাম দিয়ে দে, তুমি দিয়ে
15th April.
দে, আমার সামনে বলে দে দাদার নামটা দিয়ে দে। বলে check করো। এই সাহেব এসে গেছে।
Next.
দেখুন।
But I prefer the writ petition.
I am for the applicant, Milord. Milord, on last occasion, your lordship directed me to serve copy of my application to the all the parties. Milord, this is my affidavit
Can dispose.
service.
Consider it.
This is an addition of.
And one,
But I'm opposing it.
দুটো আছে। আগেরটা বাকি ছিল। ওহো, কেন বাকি?
Do you want to come back with an opposition or
My lord.
yes?
Yes, my lord. But will kindly grant me time to file an opposition,
Is
my
it
lord.
2024?
Milord,
But there are
is
two applications for
application
by
in
two parties.
two read petition. Two application in two read petition.
Where are this is only one writ petition.
My lord, there are two writ petitions, my lord, items 7 and 8, and each writ petition has two applications for addition.
Two applications.
Can 1 and can 2.
Right.
I have two cans. That is
But
what.
there are three different parties who are proposed to be added to the proceedings, my lord.
Both are for addition of party.
Both are. Position B.
You are appearing for the petition.
But the writ petitioner, my lord.
Who are the respondents in this matter?
My lord, other respondents I have served. That is state West Bengal District Magistrate Collector, Midnapur Kharagpur Development Authority, Chairman Midnapur Development Authority, Executive Officer Midnapur.
But Mr. Sujoy Kole was appearing for the Sujoy Bandopathy was appearing for the respondent number 4, my lord, in the writ petition, my lord.
I don't know whether he has been served, but he was appearing for the respondent number 4 in the writ petition. Yes, ma'am.
Is there, state is there, and a private individual is there.
Private agreement. But the private.
Only engineering company.
Yes.
Private
My
company is-
respondent number 4 was being represented in the writ petition, ma'am.
What about the state?
The state was not represented at the writ petition also.
So I find there was a direction for affidavits in the writ petition.
Yes, my lord, but no affidavits has been filed, my lord, till date.
Only 3 to 5 were appearing. Have you served all of them?
My lord. Copy din na, copy.
So,
Who is this? The principal Kolkata?
principal.
There is no one called the principal Kolkata.
Principal.
The service.
Principal.
Who is the principal?
Service to the principal. State of West Bengal service to principal secretary. Principal secretary.
The principal is the principal secretary.
Secretary. My lord,
Serve the GP's office. Where is that service?
My lord, on previous occasion, they were all appeared before my lord.
State did not.
no. My lord, state has never appeared, my lord. State has never appeared.
Only this.
Respondent number 3 to 5 has appeared, my lord.
Appeared.
Yes.
State did not.
I will
Please
certainly.
serve the state and come back.
My lord.
Service ko thi.
Because if they also want to come back with affidavits, I have to wait for it.
My lord.
Please serve the state and come back.
My lord.
Since service affidavit of service, since service upon the state respondents is not complete, affidavit of service link upper column, none appears for respondent numbers. There is the service on Midnapur Kharagpur also.
Yes, yes. That is hand service, my lord.
Hand service.
Yes.
Where is the hand service?
Yes, in the affidavit of service, I have annexed that.
বুঝতে পারছি না 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 বুঝতে পারছি না
Page number 3.
None appears for respondent numbers 3 to 6 despite service. Paragraph, since service upon the state respondents is not complete, comma, let the matter stand over till 4th April.
Well,
Please serve the GP's office.
Grateful. But item number 8 also similar order. Same matter.
Same matter. Same order in it. You have served the others.
yes, yes, also. One.
No, Ashu.
Grateful.
Affidavit of service, second matter declaration.
Both the matter absolute.
next one so 4th April the removal doesn't
9. 9.
একই তো
Well, it's similar order they have stated. They have taken similar order.
Item 9.
অ্যাপিয়ার করেন তুমি নাম দিচ্ছ না
The last on 20th February, I have the petitioner. You have to say right to the to find a compliance report. But after your lawsuit order was passed on 20th February, another notice there are 30 petitioners. Notice that the 7 petitioners received the notice. Out of 30. And that notice is issued by the secretary Jela Police, not the contender. It has been mentioned that notice in connection subject you are requested to appear before the office chamber of the undersigned Secretary Jela Police on 4th March. Yes, that was the date yesterday. That later 27th February. That is upon 7 petitioners.
at 12 noon with all original documents mentioned below for verification and further necessary procedure mentioned such and such. So this is the letter. And they appeared and Jila Parishad on instruction submitting, first you give an undertaking, the whatever money has been awarded, you will accept it. And not only that, the two petitioners they tell, no, though you have the 24 decimal has been acquired, but road has been concerned only on 2 decimal, so you will get it only 2 decimal land. On verbally stated. Thereafter, my client, that the 12 petitioner, they submitted a letter to the district magistrate on 4th March. That has happened. And Nodia Jail Secretary, South Divisional Jila Parishad, he is asking to appear, not contemporary. That is my submission before Lord Chief. And that is the direction to file a complaint.
Container is the superintending engineer.
Yes.
My lord,
No.
my lord,
that
past order was
What?
passed. My lord, your
Lord,
lordship
district bench has been added.
passed, my lord, your lordship passed the order.
But the compliance, you are not direction to file a compliance report. So what is the compliance report? Is file a compliance report? Then I said, file.
My lord, passed your lordship on 7th October, passed the order to the superintending engineer. Thereafter, one review application has been filed by the state. The review application, my lord, your lordship was pleased to dispose of the matter and added my lord, the district magistrate.
Yes.
Respondent number 5.
Review application was withdrawn by you.
Well, it was some modified, partly modified.
Dismissed as
Well, I am
withdrawn.
filing my compliance report.
I'll give a copy.
Pursuant to your lordship's order, my lord,
The copy?
my lord, sir.
No, I have not yet.
Well, steps were taken. The ADMLR, my lord, the head of the chairman of the district purchase committee, wrote a letter to the requiring body superintending engineer. Accordingly, my lord, the amount has been sanctioned for purchase. Thereafter, the ADM also, my lord, requested the superintending engineer to prepare a list of the land losers. That has been done. Thereafter, my lord, another notice was issued to the petitioners. My your lordship can't count to my assembly. ভাবলে কি করে আমি হইনি R7 minus page 36 for verification. It was issued upon some of the petitioners, not all the petitioners. Accordingly, R7. Well, they appeared, out of which, my lord, 8 persons, my lord, submitted their requisite documents for verification, and it has been done. Thereafter, my lord, the next page, your lordship, kindly turn to page 41. 39.
This notice was only to 6 persons.
6 persons. Thereafter, another 10 persons. My lord, not all the persons, but my lord, according to the land loser report prepared by the PWD authority, all the petitioners' lands have not been utilized or taken away. Those whose lands have been utilized, notice has been issued upon them. Then, my lord, your lordship, take turn to page 41, which my learned friend issued before your lordship. It is issued by the Secretary, South 24 district member for execution of the sale deed in favor of the Jala Parishad.
To 1 person.
No, man. It is serial. Serial. Series, my lord, your lordship.
39.
Page?
41 to
Page 41 to
56.
56. To execute the sale deed on 4th March 2024. That is yesterday. They appeared they came before the registry office for execution of deed, but they refused to execute the sale deed because, man, they have given a written letter that the lands have not been
More land utilized.
more land has been utilized. Accordingly, they are not
ready to, and they are not willing to execute the sale deed. Thereafter, my lord, another notice was issued to the rest of the persons. On 27th, for verification of the, that is on today, yesterday, on 4th.
Yesterday.
যেটা আরো সব বাকি 10 জনকে ডাকা হয়েছে ভেরিফিকেশনের জন্য বাকি 10 জনকে আবার ডেকেছে ভেরিফিকেশন আচ্ছা নোটিস দিয়ে দিচ্ছি
So all this is with regard to 6 persons out of 30.
thereafter around another 10% where notice was issued for verification on 4th. Your lordship can turn to
There are total 30 persons, I think.
30%, all the persons' lands have not been
Have you
utilized.
recorded that? It is stated in your.
আচ্ছা আচ্ছা বলা আছে দেখো but they refused, my lord, those whose persons, my lord, who appeared before the registry office, but they refused to execute the sale deed in favor of the government yesterday. And other persons, my lord, were asked for, my lord, verification yesterday, but I don't know what is the outcome, my lord. I have no
You would have received after objection.
When I shall take instruction, because I am on instruction submitting, deliver 2 persons.
My lord, one other submission, my lord, another
They
submission,
was told only that you are claiming.
another submission, my lord,
24 decimal has been
another
taken,
submission, my
but
lord,
only 2
your
decimal
lordship
has
can
been used for road.
57.
The remaining 20 decimal were entitled.
Suppose that
Can it be restored back? No. That is why my
57, page
what I am
57.
submitting, my lord. What I am submitting
It
before
is
of
also written by the district magistrate chairman of the district purchase committee, page 57 of my
that thing is done
R9
by the secretary.
for joint verification,
Jilla
my lord.
He is not the party in the contempt
ঠিক
petition.
আছে ঠিক আছে যশোর দেখছেন তো যশোর তো দেখছেন তো all the list যশোর দেখছেন তো
Now, the quantum, the area is not stated in any of the letters. It is
Well,
only land.
but the land
The area of the land.
but the report
quantum
was
is not
prepared by the
mentioned in
it has been mentioned in the my lord the report
page 34
page 34 your lordship turn to page 34
utilized area नहीं क्या 34 utilized area
utilized area 1 7 column
yes
utilized area.
Will you come back upon instructions?
Yes. And I shall file an exception also to the
Very-
report.
very. So you can annex this to your exception.
Yes, yes, yes.
Affidavit of compliance submitted on behalf of the alleged contemners is taken on record. Paragraph, learned counsel for the applicant's petitioners seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on
কয়েকটা আছে
5th April.
চেক পেয়েছি ওটাই বলো
পরেরটা করে দাও
Please serve an advance copy so that we can take up the matter on the next day.
Yes, ma'am.
Please serve an advance copy.
Yes, yes, yes. The advance copy as well.
দাও করে দাও
Lord, I am for the applicant petitioner. May I file my affidavit of compliance, my lord? That has been deposited and has been accepted, my lord. Deeds.
Yes.
Substantially been complied with. Your lordship directed me to pay 12,10,881, and that has been deposited and received by the authority concerned, my lord. That is at page 7, my lord, annexure A. This was the forwarding letter, and the next is the
on
demand draft.
By the collector received the amount with some time by
In this
not
one,
disbursement in this one.
Yes, my lord, that was originally in the order. At 2 weeks time we give.
They have deposited with us.
We should
In original order, my lord, there are two parts of the order. First part, my lord, they have complied with according to them. My lord, in the second part, my lord, your lord, kindly direct the district magistrate and collector to disburse the same, my lord, within a week from date. There are two parts of the order. First part have been complied with, has been complied with. And my lord, in the second part, my lord, the district magistrate and collector, my lord, shall be directed to disburse the amount
সেই তো আমরা টাইম
within
চাইতে এর মধ্যে
a
আমি
week
দিয়ে দেবো
from date. my lord. This is my only submission.
1 week.
my lord there was an order after deposition receipt 2 weeks time was your lordship was passed in order we have not paid 2 weeks
Everything is
time.
over.
Yeah.
That 2 weeks
But
is
what
not
minor
over.
Friday we have received my lord kindly please Mr. Pilot, is there inside this law?
Direct him,
Sir,
to
this is
file
the last
compliance
final one.
report, compliance report.
Yes,
Matter we kept pending.
Not a problem.
you are the district magistrate or collector.
System magistrate. Howrah.
We shall disburse in the meantime.
In
And
the
the
meantime,
contempt number,
Content number 3, my lord.
contempt number 2, 3,
Contempt
3, my
number
lord,
3,
3.
3.
No, my lord, I am on behalf of
One and-
contempt 1 and 2, my lord. They be discharged, my lord. Insofar as 1 and 2 is concerned.
It is submitted on behalf of the, affidavit of compliance submitted on behalf of alleged contempt numbers 1 and 2 is taken on record. It is submitted on behalf of the alleged contemners that the amount of rupees 12,10,881 as directed by this court has been deposited with the
District magistrate and collector.
district magistrate and collector Howrah, being the third alleged contemner
Second
hearing.
respond.
Nah.
In view of the above, the contempt proceeding, insofar as alleged contemner numbers 1 and 2 are concerned, is dropped. Paragraph, learned counsel for alleged contemner number 3 seeks 2 weeks accommodation, weeks apostrophe, accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 20th March.
Lord, 2 years. 2 weeks.
20th March.
अरे बोले
8 March.
20th.
13 in this matter, Lordship, I am led by Mr. Partha Pratim Rai. He is appearing through Lordship
Yes,
online.
sir.
Last occasion, Lordship, the service could not be placed before your Lordship.
Served.
Yes, Lordship.
Yes, my lord. The evidence service is there, my lord. All are been served. This is regarding the Puri matter. The property lying at Puri belongs to the petitioner, which is
I think the councils have changed in the meantime.
no. After that, my lord, the evidence service there is.
Let me just find out. Is the alleged contempt?
Respondent 1, 2, and 3, because there the respondents were supposed to hand over the property in favor of the petitioner trust.
All
Page.
of contenders.
Yes, my lord, because these are youth. The principal secretary is the. Your lordship may kindly turn to the order itself, whereby your lordship was pleased to direct.
All the respondents were directed.
Yes, my lord. That's why.
Let there be a notice as
your
to why
lordship-
rule shall not be issued.
As your lordship, my lord, I
They
am
are not
not.
appearing. And I would request Mr. Dey, this is a contempt application. In the writ petition, Mr. Sushobhan Sengupta and others were appearing. So there's been a change after that. So if you can take note of this, because it is served on the alleged contemners, they are not appearing. So I have to issue rule on the next date.
Or Mr. They can take instruction. Come as your lordship. I am so the contempt is between the contemptor and the court. I should not interfere regarding.
Let them show cause. Let me see.
As your lordship.
My lord, I have no personal.
Affidavit of service. None appears for the alleged contemners despite service. Paragraph, the alleged contemners are directed to show cause as to why rule of contempt shall not be issued against them for non-compliance of the order under contempt as well as non-appearance before this court despite receipt of notice. Paragraph, the department is directed to serve notice upon the alleged contemners and submit a report to that effect on the adjourned date. Paragraph, let the matter appear under the same heading on 8th April.
Can we formally serve a copy to Mr. De?
Yes.
Can we serve a copy to Mr. De or not?
I am not on.
No. As you have indicated, that's right. Grateful to your lordship.
Good.
16.
I appeared for HITCO, my lord.
Commissioner?
My lord, Mr. Ashim Kumar Raut is appearing
Yes,
for
where
the
is he?
but he could not come today due to personal difficulty, my lord.
Petitioner.
Petitioner.
It was restored on the earlier date and they are absent. I'll dismiss it. No,
My lord,
petitioner has no case.
state has not been served the copy, my lord.
Serve the copy statement now. Time.
But we are appearing that as the copy was not served to us, my lord, that is fine.
Please serve it today itself.
আজকে আমাকে করে দিও।
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th April.
Namta.
Next.
16.
This is that writ petition, my lord. I am backed by Mr. Mohendranath Gupta, who is on his legs. The writ petition earlier occasion, your lordship has passed an order in respect of inclusion of the amendment portion 16A and 16B. I have included and filed a writ petition amended and also served my learned friends in that regard.
My lord, my lord, this is my lord, please see. Report is not served.
This is received by Mr. Ghosh.
Please see, report is not served. Along with this, please see. You have given this.
Mr. Ghosh has received it. Mr.
Are Baba, receive this. This is the file. Please see the file. Whether report of the state is including this or not.
No, not required. Report is with you.
Why then you served us?
My lord,
As
the fact is that in earlier occasion, your lordship has passed an order to file a report on basis of the affidavit, and that report has been filed, and thereafter your lordship has that is the past.
My lord, this is a very bad practice, my lord. I want to say, my lord, please, your lordship will hear enclosed herewith. Please find a copy of the
amended writ petition.
Writ petition along with all its enclosure. Through and a copy of the report filed by the state being the respondent number 3, 2, and 6 of the writ petition, along with exception affidavit in opposition filed in the writ petition. My lord, writ petition is given and the supplement affidavit is given and the affidavit in opposition of the 3 and 6 exception is there. But affidavit in opposition of the state is not given to us.
My learned friend has not appeared in earlier occasion, my lord. That is why he may not have knowledge.
He have not filed the amended writ petition in court.
My lord, filed in earlier occasion, can number 3, my lord.
Oh.
That is the amendment application.
Amended writ petition, amended writ
Can
application.
3 is the amended writ.
Can 3.
Please repeat.
Can 3. Affidavit of service.
Amended writ petition. Supplementary.
Affidavit of service.
My lord,
yes, I have personally served, my lord. Mr. Ramchandra Puchayat clerk has received it, my lord. That was on
But
8th
Mr. Bandyopadhyay was
January.
appearing in this matter earlier.
8 January 2024.
Can 3 is not in the file. You have not filed.
So can 3 is there, my lord. দেখুন, an order has already been passed in that respect also. দেখুন আর একটা দিয়ে দিচ্ছি কি আছে একটা দিয়ে দিই হ্যাঁ এমন ডিসপিটিশন আমি দিয়ে দিচ্ছি একটা কি আছে
করছেন মানে
amended petition উনি বলছেন রেকর্ডে নেই
না না আমি বলছিলাম চেক করে নিতে যে
Where is the amended writ petition?
amended petition দিয়েছি
আর একটা সময় নাও না নিয়ে আবার
রেকর্ডে নেই তাহলে আমি দিয়ে দিচ্ছি আর একটা
মানে take it kindly take it 1 week after. My learned friend says that it was filed in court, but if it is not there, I must file it.
বার করছি can three let me
Oh.
see. Give me a minute please.
বলছেন যে আছে ঠিক আছে মানে এই এটা দেখো আচ্ছা ঠিক আছে
Can
এই
please
কপিটা দেখো
amended
কপিটা দেখো
petition.
রাইট
এই এক্সেপশনটা দিয়েছে এটা রিপোর্ট ফাইল বাই দ্য স্টেট রেসপন্ডেন্ট 3 and 6 এটা দেয় এটা দিয়েছে আমার কপি তো দিয়ে কপি গুলো কি বলছেন দেয়নি এই দেখো তুমি দেখো না তুমি
অ্যাডভোকেট নম্বর 6 তো
ওকে জিজ্ঞেস
দিয়েছে
করছো এটা হচ্ছে সাপ্লিমেন্টারি এইটা হচ্ছে এটা দিচ্ছে এবিটিভি ইন এক্সেপশন হ্যাঁ হ্যাঁ exception of
advocates at different time different persons appeared
যদি আরেকটা চায় দিয়ে দিন
দিয়ে দেবো that is সেটা দেখ
আর এটা হচ্ছে রিট পিটিশন হ্যাঁ এখানে লিখেছে দেখো পড়ো
রিপোর্ট তো এইটা
এন্ড ঠিক আছে ওটা লাস্ট সাপ্লিমেন্টারি না 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 ওটা লাস্ট ঠিক আছে ওটা দিয়েছে এই দুটো দেয়নি এন্ড এ কপি অফ দ্য রিপোর্ট ফাইল বাই দ্য স্টেট বিং রেসপন্ডেন্ট নাম্বার 3 and 6 আচ্ছা বলছি রিপোর্টটা তো স্টেটের আমি দিয়ে দিতে বলছি দিয়ে দাও আমাদের কাছে নেই থাকলে তোমাকে ঠিক আছে স্টেট যে রিপোর্টটা দিয়েছিল ওইটা 3 and 6 দুটো রিপোর্ট দিয়েছে পরের দিন করে my lord I pray some time my lord next date my lord your lordship will that this matter my lord as because as the report is not in my brief my lord so it is not possible for me to my lord পরেরদিন করে দেবো না it there is no my learned friend was actually not appearing previously my learned friend just pointed out that the report filed by the state is not with him there is no difficulty in handing over a copy because it is the report of state possibly Ramchandra Guchait and another advocate.
And sir, Mr. Bandyopadhyay's name is recorded here.
Yes, my lord. I do not know
Yes.
what happened. There has been thrice changes, but doesn't matter. I will give a
Please hand
report.
over a copy.
Yes.
A very minor issue, please hand over.
আচ্ছা কোন অসুবিধা নেই
Contrary of the respondents, the matter
আচ্ছা
is
দিও ভাই
paragraph, the matter appeared under the same heading.
আরে আমি সব সময় এই ঘরে থাকি
8th April,
দিয়ে দিন আসলে চেঞ্জ হয়ে
8th
গেছে
April.
গ্রেটফুল
short date মানে ওটা short date will be given
There are holidays in between.
next date appeared date
দিতে হবে না মানে this application was made for removal of a bus stand in my property. Now instruction is the bus stand is going to be removed within a very short span of time.
So let it be adjourned.
Kali adjourn it so that I can get the letter from my client and make it disposed of.
Allowed as a last chance.
No, on that ground, I am not filing anything. Because if this is the situation, the deed preacher will be infructuous.
It is submitted on behalf of the petitioners, comma, on instructions that the grievance of the petitioners in the writ petition, there is a possibility of redressal of the grievance of the petitioners in the writ petition within a short while. Paragraph in view of the above, the matter is adjourned. Paragraph, let the matter appear under the
Fortnight
same
will
heading
suffice.
on
Fortnight will suffice, I think.
3rd April.
Great.
On 19 Miller, I am for the petition.
19 and 20 are the identical matters.
Well, the matter relates to whether I am entitled to get leasehold right or the outright sale. Well, that matter is your lordship kindly see the as per notification I am entitled to get the sale.
This is an exception.
But till date I have not received any exception.
Yes, exception on the last occasion, because the first supplementary affidavit we have filed. And thereafter, my learned friend filed a second supplementary affidavit annexing some other deed of,
Yes.
deed of conveyances.
Yes.
My lord, I have taken instruction. My lord may consider this, and primarily, my lord, the first exception to the opposition to the supplementary affidavit, we have disclosed the situation under which all those deeds were executed. If you
Executive deeds of sale.
Yes.
yes, under the in my first opposition to the first supplementary affidavit, I have disclosed, and the so far the second supplementary affidavit is concerned, my lord, I can show to your lordship, my lord, the instruction I have received. My lord, in addition to my contention in the opposition to the supplementary affidavit, this much only can be added to, my lord, this instruction. I have not prepared an exception because
You practically admit that deeds of sale
Yes.
were executed.
Yes.
were executed, but under a peculiar circumstance, my lord.
Let another be, there will be a peculiar circumstances. I meant it.
Lordship will consider that in my report, supplementary report to the
There is
opposition.
This instruction.
Nothing. No, that is why, my lord. And on the last occasion also, my lord,
Because you are agreeable to grant leasehold right. The
Leasehold
petitioner is asking for an outer
Ask
of
you-
sale.
yes. If your lordship, for a moment,
And except
I don't think that my learned friend has my lord, many things to say. My lord, if I am
you have to clarify actually. You have
yes
stated exceptional circumstance. What is
Ex-
that? What is the exceptional circumstance?
under, my lord, as it appears from the instruction, my lord,
Exceptional case.
exceptional case under the orders of the court,
No. Against the orders of the court, not under the order of the court.
against the order of the court and other cases.
What does that mean? Against the order of the court? Please show me the order of the court that the court says that execute lease sale deed. I'll pass a similar order.
Yes.
If your lordship, my lord may consider my first supplementary report. That will make the things clear.
Give me.
That was affirmed on
Yes,
5th April. 5th
Yes,
April.
yes.
My lord, may I take your lordships to some of the paragraphs? Because in the first
5th April or December.
supplementary affidavit, my learned friend has taken a point that one Shantanu Sengupta was favored with the sale deed, but in his case, in their case, the sale deeds were not executed. My lord, paragraph 3 onwards, paragraph 3 I have stated that is regarding acquiring of leasehold interest in the property. And then, your lordship, kindly, the situation.
Yes.
My lord, paragraph 4. Regarding execution of sale deed, these were the situation, my lord. Initially, a writ petition was moved, that was allowed, and direction was given. We preferred appeal, lost, and then contempt was filed, and then, my lord, the authority
Yes.
executed. Now, lordship, kindly.
That is in respect of the same project, my lord.
Yes.
ভাই তুমি ফালতু কথা শুধু দিনের পর দিন আটকাচ্ছ।
Then, your lordship, kindly come to paragraph 5.
Yes.
Miller, may I read only two paragraphs, sir? That it is pertinent to mention here that as per the land policy of the government of West Bengal 2012, that I have annexed that policy in my first report.
But
The
one
KMD
thing, whether 12 is applicable, my allotment in 2006.
my learned friend should allow me. তুমি তো reply দেবে।
And that was considered by the division.
Let my learned friend complete his argument and
There is no exception.
Will you please allow him to complete his argument?
Let him approach.
if he goes on making running committee, then it is very impossible. The KMDA can only execute the lease, deed of lease. However, the government of West Bengal, by notification number so and so, on 17th January 2023 has introduced a scheme. That is West Bengal Land Conversion Leasehold to Freehold Scheme 2022, whereby the state government has allowed the individual flat shop owners to apply for conversion of respective share from leasehold to freehold. The petitioners in the instant case may also apply under this scheme for conversion of their leasehold right to freehold rights after getting the lease deed executed. Well, this is the scheme, my lord. I have annexed. At Lordship, kindly come to page 16. This is the scheme introduced by the government. Even that was modified. Even and subsequent
2023 scheme.
2023 scheme. It is subsequent. That is why in this case also petitioner may directly, Millard, first of all, Millard, lease has to be executed. Then he can apply for.
Please show me where is it stated that you can only grant lease and not freehold title?
Yes, the first report in the first. Let me place this.
The notification.
In this notification. No, this is 2023 notification. Here, Lordship will find chapter 2 at page 17. The lessees, mutated lessees, assignees, as the case may be, may apply for such conversion.
No
So if once we are allowed to execute lease deed in favor of these petitioners, my lord, they may apply for conversion. Then, my lord, at no extra cost.
Please show me the rule showing that you can only grant leasehold interest and not freehold title. Where is that rule?
Not rule. Lordship will find my first.
This is the first report.
No, this is supplementary. Lordship will find kindly take my report, the first report. Well, that was affirmed on 5th December 2022.
Yes.
Lordship kindly sees this. Paragraph 4 regarding, we are not denying that the 2005 that we have launched that scheme. And 5 that was regarding allotment. I am not troubling the Lordship.
Outright sale of 3.
Yes, we are not denying, my lord. That we have. Then paragraph 6 also, my lord, regarding outright sale, that may I read this paragraph 6. Although it was mentioned in the brochure that the apartment will be conveyed to the allotee on outright sale basis, but later on it could be detected that the authority itself does not have freehold right, title and interest in respect of the flats and apartments in question at the housing complex, that is Purva Avashan, having been constructed on the land which is under the control and management of the state government, and the KMDA has only leasehold right over the said land. In other words, the KMDA itself has a limited and a restricted right merely as a lessee under the state government, and therefore it cannot confer a better title than that of the title it possesses in respect of the said land. In the meantime, the next paragraph, the state government has also introduced a land allotment policy with a order number so and so dated 26th December 2012, which has been made applicable to the land owned or held by any department of the state government or agency funded by the state government, In the said policy, it has been stated inter alia that the land allotted to any individual, company, institution, etc. under the policy would be transferred to them by the government and its parastatals. We are one of the parastatals by way of long-term lease for a period not exceeding 99 years, with the option of renewal of such lease for the like period on the same terms and conditions and to such other terms and conditions as may be imposed and included in such renewal lease deed. Such a question, next paragraph, such a question thus arose as to whether the KMDA would execute a sale deed or a lease deed in view of the fact that initially applications were invited by the KMDA for allotment by sale of a residential apartment at Purva Avasan. The possession letter also mentions that apartment will be transferred by way of sale to the allottees personally or at his or her choice through the cooperative society, housing society, to be formed by the allottees of the housing complex after full payment of the final price. It has also been mentioned in the brochure that all transfers shall be executed and registered in the form prescribed by the KMDA, and the stamp duty, registration fee, and all other expenses related to the execution and registration of the deed of transfer shall be payable by the transfer. The matter was therefore put up before the Land and Flat Allotment Committee. This is a committee constituted under the Town and Country Planning Act, held on 25th July 2016 with regard to execution and registration of pending deeds at Barakpur housing projects. It's similar identical situation in respect of another housing project. It appears that the resolution of the 27th meeting of the Land and Flat Allotment Committee held on 21st December 2015 regarding the registration of deeds at Barakpur housing project phase 2 was referred, wherein it was discussed and was resolved that KMDA cannot confer a better title than it possesses, inasmuch as the KMDA has only leasehold right in its favor, and therefore only lease right may be given. The decision of the LFC was ratified subsequently by the 181st authority meeting, that is the board meeting I referred to. My lord, thereafter, my lord, it is worthy of being mentioned here that on this particular issue of execution and registration of deed of conveyance, a few litigations were instituted before this honorable court at the instance of the allottees concerned of different housing complex of KMDA. And the honorable court, after hearing the parties and also considering the predicament of the KMDA authority, was pleased to permit the KMDA to execute lease deed in favor of those allottees with some modifications of the standard lease deed of KMDA in certain cases, and in some cases permitted the KMDA to execute lease deed in its standard format. Those cases are similar to the instant case. So, my lord, I have also annexed some of the orders passed as I have, my lord, narrated in this paragraph. Some of the orders, my lord, because in the brochure it was stated that in the standard format of KMDA, in those some orders, my lord, some restrictions were, my lord, directed to be removed.
The orders were on consent of the petitioners.
My lord,
Because the
ultimately
petitioners agreed to execution of a deed of lease. The court ordered.
Yes, that was, my lord,
Not a
considered.
contested order.
Ultimately, it is reflected from the order, but they fought up to, my lord, even appeal was preferred and contempt was moved. But the honorable court appreciates the predicament. Since we do not have the freehold right, even if we are directed to execute the sale deed, whether right will flow, freehold right will flow from this execution or not.
There is the document showing that you do not have freehold right. You are only a lessee under the government. Where is that document?
That deed I have not annexed.
That KMDA is only a lessee.
Yes.
You claim to be a lessee under the state government.
Apart from these two orders, my lord has seen the Indo Power and MFARS order. Lordship Lordship may consider the page 32 of my report. This is a case, my lord, where even 2012, what my learned friend is submitting that it is not applicable, the honorable court held that no, you cannot apply that policy. Even then, Lordship, kindly, this may be relevant for deciding this case also. And my lord, this case was decided in favor of the petitioner. There, my lord, our plea of that land policy of 2012 was negated by the Honorable Court. If you, Lordship, kindly come to the operative part I am showing, my lord. This is lengthy order. Yes. Yes, discussion. My lord, may I read? This may help. The situation is the same. The same problem we are facing in some other, my lord, housing projects also. After introduction of this 2012 policy, it's a mistake on our part, my lord. We have not scrutinized at the time of floating this scheme, advertising, and it came to our, my lord, notice after this policy came into being. My lord, may I read from page 41? Discussion of by the court. Since the issue of maintainability of the writ petition has been raised by the respondents, I intend to deal with the same at the first instance. From the case made out by the petitioners, it appears that the cause of action of the instant writ only arose only upon issuance of a letter dated 22nd November 2016 by KMDA in favor of the Secretary of the Housing Society, forwarding a pro forma of the lease deed for execution. A notification dated 10th November 2016 was issued by KMDA, was also forwarded along with the aforesaid order. In the said notification, KMDA for the first time disclosed before the petitioner that as per the decision taken by the competent authority in KMDA, only lease right can be transferred in favor of the allottees of Barakpur Housing Society Phase 2 in view of the order dated 26 December 2012, that is the land policy of the government, issued by the government of West Bengal, Land and Land Reforms Department, Land Policy Branch. The petitioner has made a specific prayer in the writ petition for issuance of a writ of certiorari and a further declaration that the notification dated 10th November 2016 and the order dated 26 December 2012 does not have any manner of application in the case of the petition. The prayer of execution of the sale deed becomes consequential only if the aforesaid prayers of the petitioners are allowed. The issue before the District Consumer Disputes Redressal Forum was entirely different. Before the forum, the society complained of the deficiency of services in services of KMD, and the judgments delivered on 9 January 2013. The order of the State Consumer Disputes Redressal Commission was passed on 10th March 2014. The cause of action of the present writ petition arose long thereafter in November 2016. Accordingly, my lord, I pausing here for a moment. Thus, this petitioner, before moving this writ petition, had availed the remedies, my lord, before the District Consumer Forum. That has been referred to. No, accordingly, under no stress of imagination can the writ petition be considered to be not maintainable. Moreover, the prayer for issuance of the writ of certiorari and the declaration not to give effect to the order issued by the Land and Land Reforms Department, Government of West Bengal, could not have been made or decided by either the District Forum or the State Commission. As such, in my considered opinion, the writ petition is maintainable before this court. Now I intend to discuss whether the order of the Land and Land Reforms Department dated 26 December 2012 and the notification dated 10th November 2016 could be made applicable to the petition. Admittedly, KMDA published the brochure inviting applications for outright sale of apartments of Barakpur Housing Project Phase 2. The project is located on the Barakpur-Kollani Expressway near its crossing with Barakpur-Barasat Road adjoining CMDA now. Barakpur Housing Complex is about 2 kilometers away from the Barakpur railway station. The brochure claimed that the complex would have various facilities, viz. Bituminous road, the path and pathways, deep tube well, best piped water supply, different issues, Milord. Milord, yes. The factual aspect, Milord, I am not troubling your lordship. Then kindly skip to these are the facts of that case discussed. My lord may come. Lordship, kindly page
Decided
45.
in favor of the petitioner.
Page 45. Even then, Milord, I am relying, there are reasons. Milord, page 45, Milord, may I read from the Joint Secretary. The Joint Secretary KMD affirmed an affidavit in opposition wherein it has been mentioned that the authority is not in a position to execute any sale deed for conveying right of outright sale as the authority itself is lacking such right over the land in question. Owing to such lack of title and freehold right, KMDA started executing lease deed in favor of the allottees. A copy of the lease deed executed, one of specimen copy was given. The lease deed, which has been annexed as R2, that is 24th June 2003, the said lease deed has been executed between the governor and the state of the state of West Bengal as the lessor and the KMDA as the lessee. Milord, there, Milord, we had annexed the indenture which was executed by the government in favor of the KMDA, wherefrom it appears, Milord, that was not a freehold title was conferred, but a leasehold right was conferred. That has been referred to in these paragraphs. Then, your lordship, my lord, I skip this paragraph, page 46. The order dated regarding the policy of the state government. The order dated 26 December 2012, which the KMDA relies upon, clearly mentions that to introduce uniformly reduced discretion and case-by-case decision making to ensure transparency while dealing with public assets, the land allotment policy was being made, and any land allotted under the policy would be transferred by long-term lease. The order under reference did not have any retrospective effect. The land allotment policy came into effect on and from 26 December 2012, not prior to that. In the instant case, the petitioner applied for allotment of apartment in 2008, when there was no existence of the said policy. The apartment that had been allotted in favor of the petitioner was not covered by any policy. The order of 2012 cannot be made applicable in the case of the petitioner. The petitioner contended the Barakpur housing project is a follow-up of Barakpur housing project phase 1, wherein the KMDA had executed deeds of sale in favor of the respective allottees. KMDA ought to have executed the similar deeds in favor of the allottees of phase 2. The plea taken by the KMDA for not executing the deed of sale in favor of the allottees of Barakpur housing project phase 2 appears to be highly dubious. Since 2006, KMDA represented before the general public that they were the owners of the land in question, and the apartments constructed on the said land would be available to the general public by outright sale. KMDA held on the said stand, the KMDA held on to the said stand before the Learned Consumer Forum and also before the Learned State Commission. It is only in the year 2016 KMDA took resort to an order passed by the Land and Land Reforms Department in December 2012. Curiously, from 2012 to 2016, when the complaint case filed by the society was pending before the Learned Consumer Forum, KMDA did not rely on the said order. The KMDA, in fact, affirmed affidavit indicating that the deed of sale could not be executed due to non-compliance of all the formalities by the LOD. In the written statement, there was no whisper in the impugned order of the Land and Land Reforms Department. In the affidavit in opposition filed in connection with the instant read, KMDA raised their stand lack of ownership right title and annexed a purported deed of lease in their favor. On perusal of the deed of lease, it appears that the same related to certain plots of land at Kolani District Nadia, the said deed simply lease simply did not have any bearing with the instant case. This action on the part of the KMDA raises genuine doubt in the mind of the courts as regards to the status of the KMDA in respect of the land in question. At the same time, the court cannot lose sight of the fact that prior to taking a decision for purchasing a property, a purchaser is supposed to make necessary searches with regard to the title of the property to be sold. Doctrine of caveat emptor comes to play the moment a purchaser proceeds to purchase a property. It is the duty of the buyer for making the necessary searches in the office of the land records to ascertain whether the seller had the right title and interest to sell the same to the purchaser. Prior to payment of the entire consideration money, being the sale price of the apartment in question, the purchaser, that is the petitioner's hearing, ought to have satisfied themselves that the seller, KMDA, had good title to transfer the same in their favor. Will non-compliance of the principles of caveat emptor be fatal in the facts and circumstances of the instant case? No. KMDA, being an organ of the state and a statutory body itself, should not have misrepresented the actual facts before the general public and lured them to purchase apartment in their presence. KMDA have simply misused the faith and trust which common people reposed upon it and parted with their hard-earned money to purchase an apartment in the said project. Had it been notified that the apartment in the project were up for lease, then maybe the petitioner would not have been interested to go for it. It was only with the view to own an apartment that the petitioners had invested the sum. Going back to the promise to sell the property entails both the civil as well as criminal consequences. The judgments relied by the learned advocate appearing for the KMDA is not at all applicable in the instant case, inasmuch as the KMDA has not come up with any scrap of documents to disclose their title in respect of the land in question. In the judgment relied upon by the party accepted the modified terms for letting out the property in question. But in the instant case, in the case at hand, the petitioners have not expressed their willingness to acquire the property on lease. Hence, the said order, judgment and order is not at all applicable in the facts and circumstances of the instant case. On the contrary, the judgments relied upon by the petitioners in support of their case, though applies to the facts and circumstances herein, but I cannot persuade myself to pass a direction for execution of the deed of sale in favor of the petitioner. My lord, this paragraph is, my lord, important. My lord, I am placing, my lord, the positive, negative both. This order is against me. Even then, my lord, there are something in my favor. I read again. On the contrary, the judgment relied upon by the petitioner in support of their case, though applies to the facts and circumstances of the circumstances herein, but I cannot persuade myself to pass a direction for execution of the deed of sale in favor of the petitioners in absence of specific information as regards the title of KMDA in respect of the land in question. In case KMDA is not the lawful owner of the property, then it will not have the right and or authority to execute deed of sale. Sale of immovable property is governed by the provisions of Transfer of Property Act. Section 54 defines sales as follows. Sale is a transfer of ownership in exchange for a price paid or promised or part paid or part promised. In the instant case, the offer to sell the apartment was made by the respondent at a specific rate. The petitioners herein accepted the offer made by the KMDA in the year 2006 and acted in accordance with the terms. Same. The petitioners paid the entire consideration money in respect of the said apartment in the year 2009. The moment the petitioner accepted the offer and acted in furtherance of the same, the parties entered into a contract. Though the contract was not formally written down, but there is enough evidence to prove the same. The KMDA never alleged non-payment of the consideration amount by the petitioners. As per Section 54 of the TP Act, transfer of property has to be made by way of registered instrument or by delivery of property. In the present case, the possession of the property had been delivered in 2009 upon full payment of the consideration amount, and the petitioners are in possession since then. It is only after continuous persistence by the petitioners for executing formal deed of transfer that the respondents came up with the plea of not executing and registering the same on the ground of lack of ownership. Section 55 of the TP Act specifies the rights and liabilities of the buyers and sellers of immovable property. Omission to make any disclosure as mentioned in the section under reference is fraudulent. The respondent is the seller of the property was bound to disclose any defect in the seller's title to the property which the seller in the instant case has failed to do. A mere perusal of the aforesaid provision will show that it is incumbent upon KMDA to disclose to the allotee their true status and title over the property. The petitioners were dealing with an instrumentality of the state. They were entitled to legitimately proceed on the assertion that the respondents, as statutory body and instrumentality of the state, were the owners of the land and shall act fairly. The petitioners paid more than rupees 6 lakhs on the express promise by KMDA that as owner, it will execute and register deed of sale on payment of the full consideration price. The petitioners will be deprived of weighing the apartment in absence of a deed of sale in their favor. In law, it is the obligation of the vendor to convey an encumbrance-free good marketable title subject to contract to the country. In the present stand of KMD to execute lease deed in favor of the petitioner means the petitioners can never be absolute owner of the apartment. The lease deed will be the subject to renewal by KMDA. The rights and privileges as owner of an owner are quite different from that of a lessee. KMDA has undoubtedly failed to perform their part of the contract. Every breach of contract gives rise to an action for damages. It is settled law that where a party suffers by reason of a breach of contract, damages are to be granted so as to place the suffering party in the same position as if the contract had been performed. The conclusion. In view of the discussions made herein above, it is held that the writ petition is not hid by the principles of res judicata. The order of the Land and Land Reforms Department dated 26 December 2012 and the subject notification dated 10th November 2016 are not applicable to the petitioners. KMD is directed to execute the necessary deed of transfer of the subject apartment in favor of the petitioners within a period of 10 weeks from the date of receipt of a copy of this order. The petitioners will be at liberty to initiate appropriate proceeding for compensation and damages against the petitioner if so advised. The concluding paragraph, my lord, the KMD was directed to execute a deed of transfer and the petitioner was given liberty to my lord, take steps, initiate steps, appropriate proceeding for compensation of damages as earlier discussed. After this order was passed, my lord, we proceeded to execute the list. Then a contempt petition was filed by this petition. That order at page 53. As if that the Honorable Court directed the KMDA to execute sale deed instead of when we offered to execute the sale deed, that's a violation. And the contempt application was filed. That was disposed of, my lord, on 21st August 2019. The petitioners have filed the instant contempt application alleging violation of the direction passed in the judgment dated 12 October 2018. By the said judgment, the respondent authorities were directed to execute necessary deed of transfer of the subject apartment in favor of the petitioner within a stipulated time. The petitioners were given liberty to initiate appropriate proceeding for compensation and damages against the respondents if so advised. In compliance of the order passed by this court, the respondents by a communication dated so and so have forwarded a copy of the draft lease deed, what I submitted, and have indicated their willingness to execute the sale in their favor. the petitioners have been requested to contact the office for completion of the necessary formalities in order to execute the deed at the earliest. It is a specific contention of the petitioners that the draft deed has been forwarded in favor of the petitioner.
This is again on consent.
No.
The petitioners have agreed to execution of a lease deed.
No. Here there was no consent.
Yes.
Contempt for violation, contempt application was moved as if by that order sale deed was directed to be executed. That the petitioners, my lord, the rest of the portion, my lord, may I read? The petitioners tried to converse before, and in fact, my lord, we have executed after this contempt was disposed of. We have executed a lease deed in favor of the petitioner. The petitioner accepted that.
Paragraph, the petitioner's willingness. The petitioners pray for execution of the lease in their favor. It is not an order of the court, it's the consent of the petitioner. Please show me an order where the court has directed execution of a lease deed.
To execute this, have indicated their willingness
Second
to execute in favor of, in their favor. The petitioner have requested to conduct so and so.
Page 54, second paragraph.
Yes.
So the petitioners gave consent to it. Even in the other orders, it was the petitioners who gave consent. And it is
Yes.
clearly held that the 2012 rules are not applicable in this case, since it has no retrospective effect.
That I have submitted. Even though, my lord,
How do you justify your stand?
my lord, my stand here, it is not, my lord, after this order, my lord, there were various communications, and after that, this contempt was moved, and ultimately the petitioner agreed to accept that.
Agreed.
It reflects so. And it was not considered as violation. From this order, why I am, my lord, why I have annexed with my report, even if the order goes in against me, because by the spirit of the order was not, my lord, to execute the sale deed. That is why the honorable court given liberty to the petitioner to sue us for damages and compensation.
That is consequential.
Consequential, because they have suffered. So, my lord, ultimately, my lord, when this contempt application was filed, certainly, my lord, then the government, my lord, may, if I'm, my lord, given liberty, I can produce the amendment also, the contempt petition. There also alleges that the honorable court directed to execute sale deed. You are offering me.
I would just like to see one primary document that the KMDA has been granted lease and not title. That is your primary submission. Since the KMDA only has a leasehold right,
yes,
cannot confer title.
Yes.
Yes. So where is that document which says that KMDA has been granted a lease under the government and not an not absolute title?
That deed.
You claim to be a lessee under the state government.
Yes.
That to try
and
transferable rights.
Yes. My lord, lordship will find another order passed by.
The 2012 document doesn't support this.
Only the lease deed. Only the lease deed I have not annexed. That by which, my lord, we have acquired title.
You say that I cannot transfer title better than what we have acquired.
Yes. That I have not annexed in my the first report also. And lordship will find at page 67, page 57, there is another order. Another case was decided where the honorable court directed, my lord, for execution of the lease deed.
That is also on consent. I've seen that. Please come to that order. The petitioners have agreed.
Then, my lord, I need to, my lord, bring on record the deed by which the state conveyed the nature of right title in our favor.
Petitioner applied by virtue of a notification issued by you, isn't it?
Yes, brochure, advertisement. Yes, scheme was
on
launched.
The date of issuance of the brochure, You had leasehold right and not
Yes,
title.
that only the parent deed.
Even if you
That
would
can
not
that
have
can,
leasehold
that,
right, that it was a suppression on your part. Does the brochure say that?
that is what held in Usha Vishwas's case. That we ought to have disclosed that.
And by a subsequent notification in 2012, you
Yes.
cannot rectify that.
My lord,
Because
I
it doesn't
cannot.
have retrospective
My lord,
effect.
I cannot.
That
I,
is also recorded in the earlier order.
Yes, my lord, I cannot go beyond that.
In
That has
fact-
been decided.
in
That
fact,
part
the
has been
earlier
decided.
Judgment decides this case also, practically.
Usha Vishwas's case.
The one you read out just now.
Yes, I have read.
That
That is
in
against me, but the spirit of the order.
No spirit, sir.
That is
It is necessary deed of transfer. Had it been so, my lord,
The language is deed of transfer, but we have to see the order in its entirety. The entire order reflects that it has to be a deed of sale.
But
in no uncertain terms.
But my lord, subject to correction, but subject to.
My understanding on it that Honorable Single Bench has stated that since KMDA is a government organization or parastatals, that particular organization should have, at the time of advertisement, have stated the actual
disclose this, right?
Which the KMDA did not. And for that, against KMDA, damages can be filed before the appropriate forum. Later on, my lord, the KMDA, after passing this order, KMDA has invited the party, the petitioner, that you please come and execute a deed of lease. Against challenging that, they have come before this court by filing a contempt petition. There, my lord, was interpreting the necessary transfer, deed of transfer. That necessary, my lord, has been explained by my lord Justice Sinha. And my lord, which is at page, just on the next page, and thereafter, J.S. Parihar was relied, and
that is where liberty has been granted to challenge the same.
my lord, kindly come to that order, my lord, once. Yes. My lord, at page, it starts from page 53, that contempt proceedings. And then, my lord, at page 54, the petitioners tried to canvass before this court that the expression necessary will, in the facts and circumstances of the instant case, be the balance period of the 10-year lease which the respondents are holding as lessee.
This is a different aspect altogether. Whether the necessary period can be the balance period or not. Please come to the next paragraph.
Yes.
The court said this cannot be decided.
If KMDA is under state as lessee, then it has got a limited period. Then whatever period KMDA has enjoyed under the state, the rest of the period, whoever is coming, whoever is being inducted by the KMDA as proposed or whatever, then extensively discussed.
Next page 50.
That judgment in respect of the land measuring about 11 bigger than 6 caras 14 chotas in respect of that land, not for all land. Kindly come to page.
No, the principle.
Yeah.
The principle is
Principle is all set aside. The notification has been set aside, but not applicable.
Notification is not set aside. It is
Not-
said it
not
is not
applicable.
applicable. Yes.
I'm not saying that 2012 policy is at all applicable.
Yes.
Page 55.
Well, it's kindly come to page 55.
What is to be seen is whether the KMDA has been granted leasehold right or absolute right.
Yes. Prior to 2006 document. Let us collect.
Yes, prior to
What is that
2006,
document?
I would like to see that document. As in the date of issuance of the brochure, what was your right in the property?
Only to show that.
And already division bench also decided to subsequent in the same project to issue the sell it. A same project.
No, not to issue the sale deed. There again, the petitioners accepted issuance of lease deed.
But that is a separate in that case. But here is the other case they issue the sell it. Yes. কপি তুমি নিজে অ্যাপিয়ার করছো কপি যাও না ডিভিশনাল সমতা ডিভিশন
অ্যাপিয়ার করছি আমাদের দাও না
তুমি লিখে নাও
Will you come back with the relevant document?
Yes, I shall come. Milord, another, what I initially, Milord, no. I shall bring with that document. Milord, in the second supplementary affidavit regarding the 2013 scheme, which I referred to, Milord, in one matter went up to the Supreme Court. Milord, only to show that order, that scheme was taken cognizance of, Milord, by the Honorable Supreme Court. It had to be. Regarding that subsequent scheme, Milord, the 2013 scheme.
Last deed of registration done in 2022. Annexed to my documents.
A series of documents, deeds, 2015, 2016.
Though facts were to some extent different, there was
nothing different. I am also
in that case, there was amongst the purchasers, there was a dispute that referred to the subsequent parties. They amicably settled that disputes, differences between them.
This is again, he conveyed his consent for executing a deed.
Yes.
These are all consent orders. This doesn't help you. Second page, second line.
Second page, second line.
Consent
for executing a deed.
All the orders that I find for execution of deed of lease are on consent. So if the petitioner agrees, the court has no difficulty.
even in the here in the contempt petition, the petitioner prays for legal right.
I have said
Here, why I am referring to this in my second supplementary affidavit, second report, Milord, under the present scheme of 2023, even if the petitioner accepts the lease, at no extra cost, Milord, he can apply and conversion, he can get free all right.
You cannot impose this on the petitioner because your brochure says freehold title.
What is available? What is available, Milord, that we must disclose it to bring it to the notice of the Honorable Court.
No, but this is immaterial.
Material in the sense, Milord, it can be. The freehold right, he can get it. Since the scheme says from license or lease.
Why will the petitioner take the pain, sir?
Milord, ultimately they will lose nothing.
Yes, I have. Why I shall I?
Milord, if
fighting tooth and nail for this, and you show one line that yes, you can get it converted. Not possible at all.
No extra cost. Extra cost. For that, no extra cost to be paid. Now, if we are directed to execute,
then I am a owner, riot, and there is a lessee.
No.
They're two different things.
If we are directed to execute sale,
no extra cost will be necessary.
That is, Milord, this scheme.
Say petitioner would be
advantageous. No. Why?
He goes for registration of a lease deed. He pays less.
And then he converts.
That is
that's why I would like to see the line no extra cost. Where is it?
Milord,
Page 17
subsequent to this scheme, that is January 2023, a modification came in. Whereby the licensing and some other categories are also brought. There the rate prescribed. Suppose, Milord, we are directed to execute. Suppose the lease deed, he accepts the lease deed. That will be the stamp duties. He will be paying the stamp duties.
So much lesser than a title deed. Yes, sale deed.
The same as sale. Lease.
That is my headache. Whether I will pay
same. The lease deed,
if he applies for conversion, then the same.
No
extra cost on instruction.
That's stated where no extra cost. I do not find it in your policy.
Yes.
The policy only says conversion.
That I have annexed, but subsequent modification I have not annexed. I could not annex. I shall.
Then, after the lease deed, they will issue another notification that clause has been withdrawn. Then I have to come to the court.
You can
have the right to withdraw that clause also. First, I will accept this.
Subsequent modification.
If there is a clause, then I would request you to accept this. Take the deed of lease and go in for conversion. That is save money.
No conversion necessary.
In case of sale deed, there is no necessity of conversion.
Of course.
That I am also paying that. Let them produce the policy of the before 2006.
No, if you are still on merit, then I have nothing. After all this, I cannot go back. These are all admitted facts.
Two things, Mr. Talukdar, two documents. One is you say no extra cost. You have to show that document, please. And another thing is in 2006, when the brochure was
No extra cost, then the lease deed to be executed.
No, I am not interested to have the lease deed. I am only sold it.
after execution
or
of
no,
the lease deed,
lease or sale, whatever to be is directed. We have to execute either lease or sale.
Yes.
Whatever he is to pay.
Yes, I will pay.
If we are permitted to execute lease deed, then he applies for conversion.
Without paying any extra.
is that possible?
Whether
Then I have to
that
take
is on instruction, my lord, on instruction I submitted. I will take
I would
further
like to see
instruction
the
and confirm
No
that.
instruction. I would like to see the document.
Yes. I
Instruction
shall come with the modified.
Well, even then there is a problem. Suppose, my lord, from other subject, my lord. Previously, in case of those who obtain, my lord, say more than 45% pass course, they will be entitled to have a extra benefit. Subsequently, that has been withdrawn. Here also, same thing happened. They have issued notification after some day. Withdraw this notification that right my ghost.
No.
Better I am entitled to get the sale.
After granting freehold right, that
If
cannot be.
Mr. Talukdar can show that after getting a deed of lease, you can apply for conversion
Yes.
of free title without any extra cost, I will record that in the order that you
Let
will
them
apply
produce,
for
and
conversion
not only that, and also they have to produce the policy of the before 2006.
documents. That in
Lordship, permit. Because
Yes,
that parent deed.
prior to 2006, you did not have title.
Yes. That suddenly, my lord, that I will have to. I shall come with the modified application, the subsequent notification, and also with the specific instruction.
The division
He has not given the
Counsels for the parties.
Copy the book.
Learned counsel for the KMD.
लिखे ना
By virtue of a modified notification subsequent to the order issued
লিখে নাও না এখন তো নেট থেকে বের করুন এফএম এ
subsequent to the notification
আরে একই লাইন
dated 17 January 2023, comma,
অর্ডারটা দিল
the
এটা মেনে নিল
lessees can apply for conversion of the lease
কিন্তু সেক্ষেত্রে আমার লিজ ক্ষেত্রে মাত্র
to
আনলিমিটেড
freehold title
সেখানে তো
without payment of any extra charges.
বুঝেছো
Also, comma,
কি করে
the KMDA
গভর্নমেন্ট পলিসি করে দেবে
possessed only leasehold interest in respect of the plot in question
তাহলে একই ব্যাপার হয়ে যাবে
and not freehold title.
রাইটটা লিখছে
A leasehold interest and not freehold title, তারপর in respect of. Possessed leasehold interest and not freehold title in respect of the plot in question.
যদি কোর্টের বাইরে গিয়ে তর্ক করলাম যে হবে বাইরে এখানে না অনেক দূরে গিয়ে দেবো আমি তো করবোই না
On the date of introduction of the scheme in 2006.
Yes, prior to 2006.
In 2005. This scheme is 5.
In 2005.
5.
In 2005.
Right.
Learned Counsel seeks to produce relevant documents in support of his contention. Paragraph, let the matter appear under the same heading on 9th April. Please serve advance.
One more week.
9th April, I said.
9th April is more than a month. More than a month.
And please serve advance copy so that we can deal with the matter on the next day.
at no extra cost, then that of the stamp duty to be paid on list date.
Well, let it be appear under heading for orders.
You are adding this.
My lord, my humble prayer, let the matter appear under heading for orders, so that for orders.
Very well. Let it be for orders, because I've heard it.
Yes,
this time.
your lordship heard the
Under the heading for orders.
আপনি পয়সা বাঁচান
Both the matters.
My lord, item number 20, my lord, I am appearing on behalf of state, only same and identical matter.
Dada. One.
You have license from.
Child for the petitioner. Praying for not this week.
Why?
The petitioner, the owner Samanto is appearing behalf of the petition, suffering from back pain.
On the earlier occasion also you sought time. I'll dismiss it on the next date. Learned counsel for the petitioner seeks further extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 9th April. Next. '22.
My lord, may I be permitted to file the affidavit, my lord, as per your lordship direction? Yes, my lord.
SUVRA GHOSH is had posted operation due to accommodation.
Yes.
1 week accommodation.
My lord, I have already served the copy, my lord. Your lordship only.
I'll record.
Yes, ma'am. Didi, এটা শুদ্ধ দেন। As per your lordship direction, perhaps my lord, affidavit in opposition.
Opposite?
Because my lord, there is some dispute for that reason.
Yes, affidavits were directed.
Yes, my lord. I have served the copy to my lord friend.
The matter was out of list. Affidavits are, the reply is not filed as yet. Have you received a copy of the reply?
Yes, my lord. All, my lord, your lordship further directed my lord to file this.
No, this is opposition. Have you received copy of the reply?
No, reply to video. My lord, your lordship can direct it
Reply you have not received.
No, ma'am.
Affidavit in opposition submitted on behalf of the state respondents is taken on record. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the heading hearing, group 1 hearing. Let it appear under the heading hearing.
Yes,
on 17th April. Please file your affidavit and reply in the meantime. 23.
I beg to appear. My lord,
In this matter, I am appearing
my lord,
for the requiring
on
body.
27th March 1992, Section 4 notification under the Act 2 was given. And as per there, my lord, affidavit or exception.
It's appearing for the state.
The last occasion, my lord,
সৌমিত্র দা নাকি?
Different councils have appeared.
Mr. Sushobhan,
Mr. Bandyopadhyay is appearing in this matter.
Sushobhan ছিল।
Yes.
Yes, we can back.
সুশোভন
Mr. Bandyopadhyay.
না
এটা কে ছিল? সৌমিত্র বন্দ্যোপাধ্যায় ছিল নাকি না?
I find different names on different dates.
হ্যাঁ।
Mr. Bandyopadhyay is there. Mr.
মিস্টার সুশোভন না সৌমিত্র বন্দ্যোপাধ্যায়। Mr. সৌমিত্র বন্দ্যোপাধ্যায় was appeared.
Ananda Dulal Sarkar for the state.
Then
Mr.
Engage another division with matter. হ্যাঁ, হানুজুল্লাহ সরকার।
You are appearing for the state.
State, my lord.
So you're not ready today?
হ্যাঁ, my lord. Next today, my lord.
One day petitioner takes time, one day state takes time. On the earlier date, you took time.
My lord, I was somewhere else, my lord.
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on
My lord, only not today will, my lord.
5th April. This month not possible.
Happy birthday.
5th April.
5th April.
4. 24.
But I am for the petitioner in this matter. Thank you, brother.
Respondents. Check. Mr. Gujai has made extensive submissions, sir.
Yes, madam.
Mr. Khan, your submission is over, I think. Mr. Gujai was making.
Yes. My lord, they filed 3 reports. In one report, they have said 9(3) be issued. But third report, they have said no 9(3) is issued. Proceedings lapsed in view of section 7 capital A.
Yes?
Proceedings lapsed in view of 7 capital A.
Yes, yes.
My lord, last occasion, the matter now, my lord, I am going to present before lordship's, my lord. Already, my lord, I want to, my lord, bring back to your lordship's memory, in the mind, lordship's mind, my lord. Almost, my lord, I completed my argument. My lord, it is a matter, my lord, where the land was acquired under the 1948 Act, my lord, Act 2. Your lordship knows very well, my lord. I already, my lord, completed my argument. Section 3, Section 4(1) a notice was issued upon them. And thereafter, my lord, land was acquired by our authority. It was handed over to the requiring body. And thereafter, my lord, the under
You have admitted that the proceeding has lapsed.
admitted proceeding has lapsed. My lord, also I made an argument very strenuously on the point that although there was a specific provision under section 7 of the old Act, my lord, 1948, my lord, we only paid the ad hoc compensation. Ad hoc compensation we paid, no award was passed. It is admitted fact. My lord, in section 7 subclause 3, there is a specific clause, my lord. If they are agreed by the said provision, said award or ad hoc compensation, they may refer a reference case to the higher authority. That is, my lord, under section 8, subclause 3(b), 1(b). My lord, they did not prefer any reference case to the court or to the higher authority. They, my lord, the land was taken over by our authority in the year 1976. 1976. The said old act, your lordship knows very well, that is amended in the year 1994, first. Then 1996, 7A was inserted. Then after receiving the consent of the president, 31st March 1997, it was expired. After receiving the consent from the president, my lord, it was switched over to, my lord, as because, my lord, the award was not completed in a specific time. The proceeding was pending. It was switched over to Act 1, 1894. Your lordship knows very well. My lord, 1997, the Principal Act, in the Principal Act 1894, Section 9, 9(3)(a), 9(3)(b) notice was, my lord, amended. No 3B notice was served. On the point, only just after coming into force, 2013 Act.
So what is the consequence?
My lord, my lord. Only, my lord, I am placing before lordships. Only just coming into force that new Amendment Act 2030, which came into force in 1st April 2014, they just filed one representation 2076, they received the award, a compensation, and you took over the land. They made one application under section 6 of the Right to Information Act 2004. And just only making a formal informal representation, after lapse of 40 years, we replied them, yes, we acquired the land, we have utilized it, we have paid you the ad hoc compensation. Ad hoc compensation. Then they have come before this Honorable High. On that point, regarding the latches and delay, I, my lord, in the writ petition, I have also, my lord, read out to you before your lordships, from cover to cover, A to Z, that there is no explanation why they remained silent for 40 years. Whether there are any representation, whether there is any, my lord, before the higher authority any appeal or my reference test, nothing else. No explanation, nothing. Regarding on the point of delay, I made an argument before lordships, and regarding, my lord, there are proceedings under Order 6, Rule 1 and 2, under Order 6, Rule 2, Order 6, Rule 1, Order 6, Rule 1, Rule 2, there is no such proceedings regarding such delay. On that point, I was pleading before lordships.
What about merits?
My lord, merits is that, my lord, delay.
Here, merits is delay.
Delay, my lord, there was, my lord, we are just arguing.
because there is a delay. Yes.
There is a
but
delay.
there is a
There is delay, considerable period delay.
Does that deprive the petitioner of his
My
right
lord,
without
my lord, we have not deprived him. They have received, my lord, they have paid, they have been given the ad hoc compensation. They demand the successor, grand successor. Even during the period of acquisition of said land, the principal, my lord, persons whose land was acquired, they never come back. Their successor and their grand successor,
The advance.
my lord,
Where is the award?
my lord, regarding my lord, I am just coming into force whether they are entitled to get the compensation under the new act or under the old act, my lord, 1948. That is our prayer. We shall pay whether under the new act or under 1948 act. That is our, my lord, submission before lordship. My lord. My lord, regarding that, first of all, they are claiming they are entitled to get the compensation under the new act. We are agreeable, my lord. We will not deprive them. Whether they will entitled to get the compensation under the new act. That is our, my lord, only submission before lordships. My lord, I have Digongbor case, my lord, first I relied before lordships. Digongbor. That is also handed over to your lordships.
Yes, yes.
Handed over to your lordships. And regarding that, my lord, the latches and delay, the Supreme Court has rejected the said prayer. The plea of the, my lord, the petitioner, that they are entitled to get the compensation. On that point, I have also, my lord, submitted the said judgment. Digongbor. The state of Maharashtra versus Digongbor.
Yes.
But there, your lordship knows very well. I cited, I also explained before lordships, that land was taken over by the Maharashtra government during a period when there is in a large portion of the area in Maharashtra, my lord, there is a scarcity of, my lord, drought area. A drought area. And in connection with the said drought condition, to supply and, my lord, give the essential service to the local persons, to the local villagers, the government had to undertake a policy. Because many of the area was severely affected. And on urgent basis, a relief was required to be needed by the government. Almost 38,000, my lord, portions of land, 38,000 kilometers of road, stretching of road was required to be constructed by the government in order to, my lord, deliver, reach the, my lords, relief funds or relief materials to the affected persons or to the affected area. That's why, my lord, on urgency basis, a land was required to be taken by the government. And, my lord, on the basis of that, we took the, my lord, government took the land. Many of the persons, my lord, voluntarily, my lord, delivered the said land, voluntarily, my lord, allowed the said land. Many of the persons, my lord, disagree. That's why, my lord, our officials, our government officials, also my lord, government officials, my lord, was with the view and also influence, also, my lord, they were also instructed by the government authority that you should influence them because on urgency basis, the road is required to be constructed. So, as if they are voluntarily giving the land as a donated land. Well, my lord, my learned also on that point, my lord, he will argue that in the division bench, it has been already decided that this is donated land. My lord, in my view, my lord, this is not donated land. Because I almost 201 persons, 701 persons disagreed with the said, my lord, acquisition procedure. They went to the court allowed them to get the award. They went to the division bench on the ground of delay, 17 years delay, rejected. Supreme Court also rejected. That, my lord, petition, I submitted before lordship on the ground of delay. My lord, I have already submitted before lordship.
You have to continue some other day.
My lord, this is very, I will take at least more than, no. My lord, on the ground of delay, on the ground of section 1948 Act, on the ground of Act 1894, I will come, my lord, I will make your submission. I will make the submission. I will take time. No, my lord, I will take time. I will take time, my lord.
Same argument repetition.
My lord, my learned friend has submitted full bench decision. Regarding that also, I will submit. And legally Supreme Court decision, I will also submit before lords.
On the next day on merits.
On the later on merits, my lord, from the very first, from the very beginning of the court, my lord.
Otherwise,
I will submit.
Cannot
No,
be, this
not
month
possible.
there are several holidays, Mr. Pan.
Well,
3rd April,
3rd April. Yes, ma'am.
Third Learned Counsel for the respondents. Paragraph let the matter appear under the same heading on 3rd April 2024.
Yes, ma'am. But may I pay one injustice before your lordship? And let it be at the fairly top, my lord.
Fairly at the top.
Fairly on the top. Deeply up. Deeply, my lord. Get to two.
Liquid matters. 709.
My lord, I am for the petition, my lord.
And I'm for the state respondent.
And I am for the private respondents. My lord, before my lord coming to my lord the merit of the case, my lord, I have filed a separate writ petition. My lord, being a private respondent in this writ petition, my lord, that is appearing before your lordship's list. My lord, item number, my lord, today's list is 226, 226, my lord. My lord, let the two matter be clubbed together.
My lord, yes, my lord. I am the petitioner in item number, my lord, 709, my lord.
I am in,
709, yes.
I am in 24255 of 23.
Yes.
I am in the petition number 24255 of 23.
24255.
It's a vested land, not as per the record. And another writ petition in the similar circumstances is pending.
My lord, item
Which has
number
been filed by the
226, my lord, that is appearing in your lordship's list as item number 226. My lord, let the two matters be, my lord, taken up together. That is my.
My lord, and allegation, my lord.
You say that he is the alleged encroacher, the private respondent.
Yes, yes. He is alleging that.
Didi 226 টা দেখুন 226
226. New motion.
226 ফাইলটা বার করে দাও
My lord, writ petition has been annexed in this writ petition. My writ petition I have served to the my lord, party. My lord, petitioner. My lord, they have annexed it.
Put together, I think that will serve our purpose. Let us see who is appearing for the state in the other matter. Are you aware who is appearing for the state in the other matter?
My lord, I
Have
have
you
to
served?
ascertain. I have to
Have
ascertain.
you served everyone?
Yes, 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 sir. I have served.
I was up for it.
Yes. What is your case?
My lord, the petitioner is owns his possess plot of land at measuring 7 decimals being comprised in plot number 167 of Ramjivanpur Mauja. My lord, Teotto, my lord.
Do
by
you
a-
have the affidavit of service of the other
My lord, I have to my lord, prepare. My lord, I have served. My lord, I have to.
the state also?
Yes, yes, yes. There is a.
I don't think I can take this up. What is the prayer in the other repetition? Does it affect the other repetition?
My lord, I appear. Well, they have also my lord, annexed my writ petition in this.
My lord, I have annexed the entire writ petition, my lord. Since, my lord, there is some documents which are very relevant. That's why
If you come back some other day, I'll take up both together. He has asked not to remove him from the land.
My lord, in the meantime, I will file affidavit of service. I will affirm
Yes,
affidavit.
yes.
In my petition, there are two private respondents, 8 and 9. One
Affidavit
of the
of
respondents
service.
is my learned junior friend's client.
It is submitted on behalf of the parties that, on behalf of the petitioner and the private respondents, that the private respondents have filed a separate writ petition being WPA 21832 of 2023 on a similar issue. And both the writ petitions need to be taken up together for
My lord,
consideration.
issue is different. My lord. I want to retain my land, which has been my lord, given by the government on patta. My lord, he wants to remove me on patta land. My lord, this is the main crime.
Similar issue na kore, on a connected issue. Paragraph. In view of the above, let both the writ petitions appear together on 4th April.
4th April.
Please serve in the meeting.
My lord, my lord.
So revision numberটা কত?
21,832. Grateful.
My lord, kindly give me a liberty to file, my lord, supplementary affidavit, my lord. In writ petition, my lord, number
First matter. First matter. कोई affidavit of service बोला?
I have made, I have made ready the supplementary affidavit, my lord.
Let a copy be served to
And
us.
supplementary affidavit.
হ্যাঁ আছে
File বললেন
এই 24,255 তো
আমাকে দাও তুমি আপনি ওটা
হ্যাঁ হ্যাঁ
Next. 710.
fourth April.
Affidavit of service, my lord.
Private respondent number 8 জয়ন্ত private respondent number 8 আমার কেস নাম্বার
Yes.
In front of petitioner lands, my lord. In front of petitioner lands, my lord, there was the government land. And petitioner made an application for long-term lease before the DLRO as well as the additional secretary government of West Bengal. Like, kindly see the page 25, my lord. The additional secretary government of West Bengal Maharaj wrote a letter to the DLRO to consider my proposal. That has been pending, my lord. Let it be considered, my lord.
that will be considered by the
DLRO.
Respondent number 4.
Who will consider?
Yes, my lord. Respondent number 4. Land and land.
Let this be considered within a stipulated time.
My lord, my lord.
Affidavit of service. Petitioner submitted an application before the concerned authority for grant of long-term settlement of an area of 18 decimals of land adjoining the petitioner's plot for the purpose of pathway,
man.
for the purpose of egress and ingress. Stop. Filed an application বললেন না the concerned authority ওখানে on 5th February 2023 করুন 5th February 2023. The said application was forwarded by the additional secretary to the government of West Bengal to the additional district magistrate and district land and land reforms officer, Purbo Medinipur, by a letter issued on 17th February 2023, requesting inquiry into the matter and submission of a detailed proposal for grant of long-term settlement in favor of the petitioner. Stop. The matter is still pending. Paragraph, learned counsel for the petitioner seeks a direction upon the authority to consider the application at the earliest. Paragraph, learned counsel for the respondents submits that the fourth respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of directing the fourth respondent to consider and dispose of the application submitted by the petitioner dated such and such within 1 month. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which. Next. 711.
My lord, Mr. Trivedi is appearing for the petitioner. He is on a lake before court number 21. My lord, I'm praying for not today.
Not today takes us to the next month. Where is your affidavit of service? Have you served the respondents? On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th April. মেনশনিং হচ্ছে না তো এগুলো কমাই সেম হেডিং না সেম হেডিং
Straight up. তুমি আছো তো, আমি 5.
712
Not I appear for the.
I am appearing on behalf of the.
Not,
I am
believe.
I appear for the respondent number 5.
I am here for the 6.
My lord, ABDB of service the kept on record.
My lord, this is a matter which pertains to acquisition of land. My short point is very simple, my lord, that the respondent authorities who had acquired the land after paying me compensation, subsequently it was found by physical measurement pursuant to your lordship's order in another matter that they are enjoying land more than what was acquired, kept it within their boundary wall without giving you either compensation or acquiring the land. My lord, your lordship when it takes up, my lord, page 57 first.
Which?
57.
Hello?
67.
57.
57.
57. 57.
57.
Yes.
Then at the top, your lordship will see that this is the acquisition of 4.90 acres were acquired. And the following page is a map. There was a subsequent acquisition the next year, which will be appearing at page 60. Also of another portion of the land. Now, in view of both the acquisition, the total area acquired was 9.97 acres.
60 আছে আপনার কাছে কপিটা?
Subsequently, we were
এটার পর
unaware of the fact that subsequently, pursuant to your lordship's order in adjoining this petition, which your lordship will find at page 62.
4969.
I'm sorry, Bernard. At page 67, your lordship at page 67, your lordship was pleased to pass the order at page 68. Your lordship will see paragraph, the third paragraph, my lord. Your lordship was pleased to direct joint measurement by the parties. In course of the joint measurement in this petition,
68.
we come to learn that nearly 4.240 acres, this is very important, in several dark numbers, were enjoyed and occupied by the authorities without either acquiring the land or paying us rental compensation, or even also saying that we are in possession of the land. Along with the land is possessed by the Department of Police, Irrigation and Waterways Department, as also the portions of the KMC. Now, I have taken up from the 73 onwards of all the dark numbers which I have made the complaint. The last will see at page 73 that on the right hand side, at page 74, now the last will see the information given is that it is in the name of my predecessor in interest and it is enjoying with them. And Dakholdar becomes the Irrigation and Waterways Department. Now, I will not trouble your lordship right now. All that I make a suggestion to your lordship is this. To expedite the matter, your lordship kindly directs the respondent number 8. If your lordship takes up, who is the respondent number 8? Because this is an issue I don't want to find it out at this present moment. Let the truth come out with your lordships. Respondent number 8 is the additional, let him
make an inquiry about the correctness or otherwise of my allegations. And also take the help of the respondent number 10. Make a joint measurement and then let him pass a final order.
What is
And
your
the lordship can dispose of the. I'm willing to abide by whatever he comes and says. Let him give me a hearing. All the parties be given a hearing. And let the ADMLR come
You are
up with a
saying
report.
demarcation of the acquired portion of the lands?
Yes. Because Malad, I want that if they have acquired the land, they have already taken the land. But what they have not acquired, they cannot enjoy.
Right. Yes.
Another portion is my lord,
And I have got no qualms with regard to the portions which have been already acquired.
Mr. Siddiqui is for 5.
I am for the respondent number 5. I am in possession of that particular land. That is the DG Telecommunication Lordship. May kindly recall in the earlier writ petition, earlier order of litigation, I had filed a report saying that I have my office there.
That is still pending. An inquiry was
Inquiry was done.
directed.
A report has come from the ADM and DLRO. That is of 31st March 2023. I have only one copy, my lord.
But this is a land which is separate land.
That is the respondent number 8 which my lord senior is talking about.
Land which was the subject matter of the writ petition in the other writ petition, and the land which is the subject matter of this writ petition.
No. I'm talking about the present writ petition.
In the present writ petition, the prayer is for demarcation of the acquired portion of the land.
If your lordship kindly sees, your lordship's order was pertaining to CS plot number 126 and 127 for demarcation of that particular, whether this land belongs to the writ petitioner or not. Now, my lord, after my lord elaborately hearing out this matter, your lordship was pleased to direct. Your lordship kindly sees page number 67 and 68, your lordship's earlier order in the earlier writ petition. Lordship was pleased to direct a joint inspection and survey of the plot in question, being CS plot number so and so by the government army in presence of both the parties or authorized representatives. So not certain. No, this was the third writ petition. If your lordship may kindly recall, and filed a report in this.
The numbers are different.
But I have been repeatedly telling my lord that this is not your portion, acquired portion. They could have taken all these points in the earlier round of litigation. Now, my lord, after this particular exercise has been concluded, now they again come up before your lordship saying the other plots. Which plots they have not mentioned in the earlier round of litigations. There were 3 writ petitions. This is the 4th round of writ petition. This is the 4th. Now they are saying, my lord, because we had shown a map and we shown, my lord, that these are the lands based on the lands on which this particular office is there. Because, my lord, earlier these plots were marked as CS plot, but now the premises number has been given after the CS plots are no more than the city of Kolkata. Now they are saying, no, these plots also belongs to us. You by kindly demarcate these plots. All these points could have been taken in the earlier round of litigation. But I want to file a small report, my lord, with regard to the conduct of this writ petitioner. This is the 4th round of litigation, my lord. Continuously, these writ petitions are coming up.
You want to come back with a report?
I'll come back with a report in the form of an affidavit that this writ petition on the face of it is not maintainable.
Very good. That is a separate thing, but lordship will record that.
All these points could have been taken.
The joint inquiry that was directed in the earlier writ petition will serve the purpose.
My lord, and that was
with regard to different dark numbers. Lordship when it takes up the dark numbers in the present writ petition.
It was done, and thereafter, my lord, this particular correspondence was made.
My learned friend,
Nine is the joint survey report in pursuant to the earlier direction.
First writ petition was joint survey of plot numbers 126 and 127. Here the plot numbers are totally different. The plot numbers are 1.71.
Yes, it has to be. It will be different because now, my lord, they are taking advantage of all these other plots which are there in the map. All these plots are there.
Lordship will record these things. I will show to your lordship. Your lordship will take up the report of the ATMLR at page 1.
As well as acquisition in full. So, law mandates that there has to be a demarcation.
My lord, there is a demarcation. My lord, that is what I pointed out in the earlier report. I do not have the copy of the report in the earlier writ petition. There was already a demarcation. They were continuously harping upon the fact that plot numbers 126 and 127 is their plot.
which also I disputed because the names are recorded on someone else. They say they are their predecessor interest was recorded in the name of the predecessor interest. Now, my lord, my humble submission before your lordship, now they come up again before your lordship with regard to the other plots in question. They say that these plots also are their plot and these plots should be demarcated now. Now, first of all, my lord, they have to establish before your lordship that they are the owner of that particular plots. Acquisition was completed in all respect at that point of time. It is an acquisition of 75 years back. Whether that acquisition can be challenged at this stage or not.
I'm not challenging. I'm not challenging the acquisition.
Acquired plots demarcated at that time.
Right. It was, my lord. I had shown that
No.
map. And that
No.
map, my learned friend has shown to your lordship. And if your lordship kindly sees page 58.
My lord, let my learned friend only say whether he enjoys more than 6.94 acres or not.
Lordship kindly sees.
If he
Land
retains half of
acquisition
it, that is
of
something to
police
hide.
while it is illegible of police wireless headquarters. This is of, my lord, this was sometimes around 1950, sometimes on that subject to correction.
My lord,
This
why
was
is my
published in
learned friend
Kolkata Gazette on 29th of May,
enjoying more
1949.
property? He's enjoying more property and he's saying
Acquisitions,
There were two acquisitions.
This is with regard to one.
One.
The
The other is page 61.
60.
Land acquired, police headquarters.
Of different dark numbers. You will see
Yes,
126
has to
and
be different dark
127.
numbers. Lordship, may
Different dark
kindly,
numbers.
my lord, grant me liberty to file a report in the form of affidavit. I'll come up with the entire facts as well as, my lord, I'll question the maintainability of this writ petition.
come back with the report.
If your lordship kindly considers the prayers are vague. No definite prayer is this.
Inquiry and joint survey.
That was the earlier prayer, my lord. I
Earlier
vehemently
orders
oppose, but your
express
lordship
different
was of
plot.
the view. Your lordship, my lord, I should be candid before your lordship. Lordship, there is no harm with regard to that joint survey. I also considered to that fact there will be a joint survey. There was a joint survey, and finally it was found that these are the lands which do not belong to them, that these are acquired lands, and the lands in those lands, my lord, our offices are there.
The earlier joint survey was with regard to two plots.
Two plots, and
Yes.
those plots have been left out. Those plots have never been acquired. Now, my lord, they again come up with regard to the other 10 plots.
Yes.
These points could have been raised in the
Your
earlier
lordship-
petition, my lord. It is also barred by constructive. I'll come back. Your lordship may kindly.
The lordship kindly, yes, my hearing. Lordship kindly looks at paragraph 28. The lordship kindly take the paragraph 28. 28.
My lord, there are two.
Heard learned counsels for the parties. Learned counsel for the fifth respondent seeks to use file a report, submit a report in the form of affidavit in this matter. The state wants to come back with a separate report? No, not necessarily. This report will cover everything. Paragraph, let the matter appear under the same heading on the 8th April.
8th April.
8th April. The state will file report.
5 will file.
There is no specific allegation against the KMD. I do not know why the KMD has been arrayed as party.
No. KMD has been added as a party because my KMD is the custodian of all the
Can
documents.
it be?
We are not the custodian.
My lord, subject to. My lord, if it comments to your lordship, can it be taken up in the 3rd week of April instead of 8th April?
There are a lot of holidays in April actually.
My lord, because 11th may be a holiday. So.
No, my lord, there is a lengthy delay in
I
the
thought
process.
15th or 16th, any day, my lord, if it comes to 15th April. 15th April, I'm grateful to.
15th April is, I think it's because of
any day.
Poila Boishakh or something. Poila Boishakh, I believe.
713.
My lord, before my lord takes up 713, my lord, 711, my lord, was my matter, my lord. I was on my legs before courtroom now 20. Now, my lord will kindly, it will be disposed of in one line, my lord. Because I had asked, my lord, they had.
I have already given a date. Please come back. I cannot.
My lord,
No, please come back. 713.
Lordship, Mr. Shobhan Mujumdar appearing behalf of the respondent number 7. He have gone through a surgery in his right knee. But I am praying 2 weeks time, Lordship.
7 officer in charge. What happened after
No. Loknath Construction.
7 is the officer in charge of the police station.
Loknath Construction, Lordship. 713.
8. Loknath Construction is 8. Yes.
Respondent number 8, Lordship.
On prayer of respondent number 8, the matter is adjourned. Yes.
My lord, after filing of this writ petition, the authority has made some development. The authority has written to the petitioner that we have taken steps and we shall demolish. So, my lord, your lordship direct the authority to consider our representation because they have.
I cannot because the private,
My lord,
yes, shall I direct
my
the
lord, my lord, I am appearing on behalf of the Honda Development Authority.
on behalf of?
Honda Development
Yes.
Authority. My lord, once critical.
Mr. Mojumdar is not there today. I don't think I should pass an order in his absence.
Mr. Shobhan Majumdar, Loknath Construction and appeal.
Let him come back.
Bobby.
He's undergoing some surgery, she says.
Then let it appear tomorrow as in his position.
He's undergoing surgery.
Okay.
So
Surgery,
it will appear
ডান
tomorrow,
হাতে
sir?
মাল
No, no.
থেকে ভেঙে গেছে।
No.
On prayer of the কি বলুন? The matter is adjourned. Paragraph, let the matter appear under the same heading on 5th April.
Grateful lordship.
We are afraid of reaching the matter.
14.
Okay.
It will appear under the same heading.
Because in High Court, once it is gone.
It is difficult. I understand it.
714 Lordship, I appear for the petitioner Lordship in this matter.
Yes.
I am appearing the respondent number 18.
Here Lordship, this matter was taken up last on 8th of December. And Lordship, what we came to learn, Lordship, a similar writ petition was disposed of by my Lordship.
Yes.
Wherein I was not made a party, and Lordship, but it affects my interest, Lordship. In this regard, may hand over a judgment of the Honorable Supreme
Yes.
Court.
Do you want to make some submission? Yes, I think.
My lord, I am for the private respondent, my lord. Kindly in this matter, my lord, kindly we not this week, my lord.
She's asking for an adjournment.
Lordship, in that event, can it be taken up next week if it pleases my...
Month is difficult because we have several holidays. We just have 2 weeks in this month. So I'll allow you in April.
Because Lordship, my interests are being affected badly, Lordship, because we are poor fishermen.
Not your lordship, kindly see the prayer. What he has asked for, he has asking for a letter of intent issued in 2018. Now in 2023, he is asking for quashing that letter of intent. First. Secondly, my lord, how he has been interested, if your lordship kindly see the next prayer A, that is the disputed plot, which has already been covered by a judgment of your lordship.
This is
And
exactly what I'll be bringing to my Lordship. A judgment is there in place by the Honorable Supreme Court, where the Lordship under Article 226, a Lordship has the power to review Lordship. I'll place that judgment because a time is being sought for, Lordship. I'm not placing that on record.
You are for the private respondents?
Yes.
Yes, madam. You are for the private respondent?
If my lord, advocate on behalf of the private respondent, he is asking for adjournment.
On prayer of the private respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 5th April.
5th April. Grateful, Lordship.
I am for the petitioner, my lord. This is my affidavit of service. Several times I have served, my lord. The
Service is complete.
lordship, this is complete.
Mr. Day is appearing?
Yes, ma'am.
The fact of the writ petition is, my lord.
Give me a minute, please.
Lordship.
Yes.
Lordship, fact of the writ petition is, my lord, private respondents illegally excavate the blackstone on the petitioner's land, my lord. Petitioners is a charge. My lord, in this regard, petitioner made a detailed representation to the respondent's authorities concerned. That is page number 37.
Yes, Mr. Day.
Considered by the district 70 করেছো
Who will consider?
District Land and Land Reforms Officer. ma'am.
Three.
Yes, ma'am. Respondent number 3.
Three.
Lords.
You consider.
Affidavits of service. None appears for the private respondents despite service. The petitioner alleges illegal extraction of black stone
Lords.
from his land by the private respondents. Stop. The petitioner submitted a representation in this regard before the submitted a complaint for representation. Complaint. Submitted a complaint in this regard. The petitioner submitted a complaint in this regard before the concerned authority on 11th September 2023, which is yet to be considered. Stop. The petitioner pays for a direction for the authority to consider the complaint at the earliest. Paragraph. Learned counsel for the state respondents submits that the third respondent be directed to consider the complaint in accordance with law. Paragraph. In view of the above, the petitioner is disposed of directing the third respondent to consider and dispose of the complaint submitted by the petitioner dated such and such within 1 month.
Yes, ma'am.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which action.
I'm good.
Deal. Petitioner and the private respondents. Next.
My lord, I beg to appear on behalf of the petition in this matter. My lord, only difficulty is, my lord, yes. Only difficulty is, my lord, the impugned order which I have challenged. The last page is not there, though the whole issue can be figured out. But I point out that last page is not.
Not there in the.
Somehow, my lord, it got. So, my lord, in that case, your lordship can. Is that would be better, my lord.
Challenge.
That's your honor challenge. Though, my lord, on the last occasion, lordship has considered this matter on the previous writ petition and directed. From the order, it can be ascertained what is the issue. Only the last page, my lord, is not there. I don't know whether.
How many lines are there in the last page?
That has to be ascertained.
That also you're not aware.
No, my lord, I do not know. That is a difficulty I pointed out before lordship at the beginning.
Mr. Bandapathy, let the entire order come.
Last page is
Oh, last
Oh,
page.
acha. Yes.
আমার
Acha, amar kache nahi. So,
No,
but-
that's what
no, I have not. I have not gone through, my lord. In that case, acha, ekbar dekha na.
You're challenging an order which you have not gone through.
No, the substance is there. Only the last page, my lord, isn't. From the previous. Yes, my lord. Kindly take, my lord, page 63 onwards. Pursuant to your lordship's last order, this order was passed. My lord, the relevant portion starts from the bottom. Heard the petitioners at length.
First one, disbursal of the compensation amount.
Yes, I tell your lordship, what happened exactly. These petitioner belongs to the tribal community. Now, his predecessor interest was the patta holder of a large amount of land. Now, my lord, the BSF authority through the state government through acquisition got the land for putting their posting and other things. Now, my lord, he has not been given the compensation. It was not even made aware to him. And my lord, there is without any annulment of patta or anything, any procedure under the law, the land has been acquisitioned. Now, the next generation of the predecessor interest, the petitioner comes before your lordship and seeks the compensation. Now, my lord, they have admitted the fact that 49,27,000 and odd has been given by the BSF to the state of West Bengal for allowing the compensation, but it has not been given to the petitioner. Now, my lord, they say they take a very difficult stand. They say this acquisition is neither under the Land Reforms Act nor under the 1948, nowhere. So, my lord, I pose this question to myself: exactly where do I stand? I am entitled for compensation, but it is not. May I place the order for once?
Come back with a short supplementary affidavit. It has to be on record.
It is
The
yes, supplementary affidavit, my lord. Kindly grant me a short time. I will come with a supplementary affidavit. Say it at zero.
Not today only.
Only not today, my lord. Kindly, my lord. In that case, next tomorrow, কালকে করে দিতে পারবে? Client আসতে পারে? এখন করতে
Not
পারবে?
today.
My lord, a week's time may be given because
Not today or next month. You have a choice.
no, it has to be affirmed. পারবে? Yes, because it will to come from Uttar Dinajpur to affirm this.
Right?
Yes, I yes. No. My lord.
তোমাদের একটা টিএস আছে, টিএস এর খবর থেকে জানা।
হ্যাঁ, TS এরটা দেখে নিচ্ছি। Very good.
এই এখন ছবি তুলে নাও।
একটা ছবি তুলে স্যারকে দিয়ে দাও। স্যার একটা ছবি তুলে দিও। স্যার আমি দিয়ে দিচ্ছি।
Yes.
My lord, item number 17, my lord, Mr. Ashwin Kumar Rao is appearing. My lord, this is new motion. Affidavit of service has not been affirmed yet, my lord. So kindly make it note.
So they you are appearing in this matter?
Yes, my lord.
Appeal. Oh, there are private respondents.
Yes, my lord.
Since service upon the respondents is not complete, comma, let the matter stand over till 9th April.
সিনিয়র কে বলো
Yes, my lord.
এটা চলবে না আসতে বলো পরে বেশ
Next.
For the state, my lord. But in this matter, I put the private response number 18.
For the petitioner.
But I'm for the petitioner.
Who is appearing for the state? Your appeal?
Well, the state is there. But I'm affidavit of service now. My lord, my grievance is, my lord, that any unauthorized construction, my lord, is, my lord, going on. And in respect of, on the government land, in respect of that, my lord, I have made, my lord, representations, my lord, the SDU of, my lord, is to be, my lord, is to consider that, my lord.
Where is your representative?
My lord, kindly takes up, my lord, page number 28 onwards. 28, it starts, my lord. I've made the SDU, I've sent it to the SDU as well. SDU is, my lord, number 3.
But in this matter, for the private response.
Yes.
What happened? Not only the petitioner, the respondent, the petitioner also needs construction on the period.
Is this your writ petition?
No, I did objection. I made representation to the authority court, sir. That has not been considered. What happened, my lord? And not only that, he has been running his business, stone chips and other business on the PWD land. I am also. But he tried to remove my business and he want to start new.
So let both the representations be considered by the authority together.
Yes.
Yes, sir. What do you have to say?
My lord, let him, my lord, get an order in my writ petition as well, my lord. Let everything be confirmed, my lord.
And record his submission.
Certain. But my lord, kindly, my lord, records, my lord, his admission and my denial. His admission to the effect that, my lord, he is constructing, my lord, and my denial that I am not.
So admittedly, you're on government land.
Partly my land and also the in front of my land there is a
Affidavit of
not
service.
entire.
It is contended on behalf of the petitioner that the private respondent has raised unauthorized construction by encroaching upon a portion of government land adjoining his property, comma, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on the date of your representation.
Well, this is
1st September 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the private respondent submits. The private respondent admits that the private respondent has raised construction in a portion of government land and submits that the petitioner has also raised unauthorized construction on such government land. Stop. The private respondent has submitted a representation before the concerned authority in this regard, which has also not been considered. Stop. Learned counsel seeks a direction upon the authority to consider both the representations. Your representation.
Subject to correction, that is beyond the records.
On 20, what is the date?
21st November 2023.
21st November 2023. Seeks a direction upon the authority to consider both the representations together. Paragraph. Learned counsel for the petitioner denies and disputes the contention of the private respondent. Paragraph. Learned counsel for the state respondents submits that the fourth respondent be directed to consider the representation at the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of directing the fourth respondent to consider both the representations submitted by the petitioner and the private respondent are considered and disposed of. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Disposed of.
Grateful, madam.
I am for the petitioner. But I am for the state. The evidence. But my complaint is, my lord, there is a illegal construction on embankment. Therefore, my lord, under section 32A of the West Bengal Embankments Act, yes.
The private respondent, all of
Yes. My lord, all of them. I'm told yes, my lord. Yes. Yes, my lord, yes, sir.
One is insufficient address not delivered.
Not delivered, insufficient address.
518, the last 3 digits.
My lord, we have tried to, my lord, deliver at the address known to us. My lord, we do not know, my lord, where they are. Private respondent. 14 and 18.
There are 9 private respondents.
Yes. বাকিরা রিসিভ করেছে হ্যাঁ but on instruction I say, my lord, the others have received, my lord, excepting 14 and 18 because, my lord, the 14 and 18, my lord, we have tried to, my lord, serve at the address known to us.
So why don't you serve and come back?
Lord, we don't have any other address, my lord, to serve.
Find out.
Yes.
Service
Lord,
is necessary. This will be
Lord,
down
I
for
understand
appeal.
that, but, my lord, how can I find out, my lord, their address?
This court only because it's not served.
But of the, my lord, the many respondents, my lord, only 2 have not been served. And, my lord, my
So you
prayer
have to
before your
either
lordship
expunge
is,
their names or serve them.
Lord, 2 things. My lord, I have a, my lord, very humble prayer before your lordship. My lord, my allegation is, my lord, that there has been an illegal construction on an embankment. Therefore, my lord, the state authorities are the person, my lord, who has been, my lord, given the power under 32A to inquire and take steps. So, my lord, the private respondent, my lord, whether some of them comes or not, my lord, it doesn't really, my lord, make any difference. My lord, in my respectful submission,
So, but you have impleted them, isn't it?
I impleaded because, my lord, they are the person, according to me,
It makes a difference.
who have, my lord, raised the construction. Now, the difficult,
If affected by any order passed by this court, please serve and come.
but I have the address, my lord, where I had attempted to serve. But if I,
Sufficient address is not service. Since you have impleted them, you have to find out their proper address and serve and come back. Simple. Affidavit of service. Since all the private since service upon all
14
the
and
private
18 only.
respondents.
14 and 18 only has not
14,
been
18. Since service upon respondent numbers 14 and 18 is not complete, let the matter stand over till 2nd April.
As your lordship please. Huh? Deeply. Then, but under the same heading, blood. Under the same heading. Agreed.
The 2 PM correction matter as well.
I beg to appear. First page, para to Mr. Dibra is there, my lord.
It's a group 7 correction, so I wanted your presence.
No. Yes,
The first page, second paragraph. May I be allowed to read out, my lord. The primary grievance of the petitioner is that buses, including that the private respondent are applying from Sonarpur to Bagna in violation of the permit granted in their favor. Actually, my lord, permitted granted from Sonarpur to Bagna. Violation is from Ghatokpukur to Sambajar. I have stated in my writ petition as well as annexures are there.
Writ petition paragraph?
My lord. That is at page 5.
Order.
Page 5, para 5. Page 5, para 5. And in support of my submission, my lord.
It will be Shyambajar to Ghatokpukur.
Shyambajar to Ghatokpukur. I am justifying my submission by page 25, my lord.
No, it's recorded in paragraph 5. Yes, Mr. Debra? Inadvertent error has crept into the order passed on February 20, 2024. In the third line of the second paragraph of the order, comma, Sonarpur to Bagnan, inverted comma, be read as Shyambajar to Ghatokpur. এটা inverted comma. Paragraph, the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on February 20, 2024. Urgency required.
Kindly extend the time because 1 week time was there. Page 2, para 2, my lord. Page 2, para 2. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Prior to that, my lord.
তুই রিপ্রেজেন্টার দিয়েছিস? রিপ্রেজেন্টার জমা দিয়েছিস? রিপ্রেজেন্টার জমা দে তারপরে তো হবে।
কারেকশন না 6 weeks এর মধ্যে বলা আছে সেই টাইমটা বলছি। Page 1.
The representation was within 1 week from date. So that
1 week. That has to be extended. That has to be extended.
Department is directed to this order be treated as part of তারপরে করুন in view of the said correction, comma, the time granted to the petitioner for submission of comprehensive representation be extended for a week from date. Paragraph, the remaining portion of the order shall remain unaltered. তারপরে urgency. ওই no address to costs as a রাজীব কস্টটা হবে না শুধু urgency claims. Yes, next.
I'm appearing. I'm appearing.
Exception.
Agree.
Exception.
That's your lordship.
Have you served a copy?
Yes, ma'am.
They was approved.
Advance I have submitted. That's your lordship.
Mr. Mukherjee, microphone, please.
So lordship will know the facts is there. My lord, these facts is that my lord, my vehicle was intercepted due to the impositions. I mean, I have not been paid. This is the allegation that I have not been paid the tax and additional tax. Then my lord, I moved the writ petition before this court. My lord was pleased to grant leave to section 16B by which my vehicle has been released, and I furnished the the bank guarantee as well as the undertaking. And your lordship also pleased to direct to prefer the appeal before the appellate authority. Now, my lord, I prefer the appeal. My lord, this has come after the appeal has been disposed of. My lord, rejecting my dismissing my appeal, the decisions arrived at. This is the case, my lord, at present. Now, my lord, there your lordships are already directed to file a report, and my lord, your lordship will find in their report. Before that, decision page 134 is my lord, the
appellate order.
decisions of the appellate authority. And my lord, your lordship will find at page 35, page 2 of the order sheet, internal page. Then with the last portion, last paragraph. On considering the above facts and observations, the undersigned direct to the taxing officer to realize the difference of the amount of the demand served as well calculated. Now, your lordship, this is the decision arrived at, rejecting my the appeal, and your lordship will not found. This is the facts that the decision arrived at by the appellate authority on the basis of what they have considered, that is not appearing, at least that is not appearing from the order sheet. The findings of the appellate authority on the basis of my memo of appeal and the stay petition filed therein, that has not been considered. Neither the facts has been discussed, and your lordship will find their report. In their report, page 2, the report which has been furnished before my lord, filed by the non-tech office, motor vehicles inspector, non-technical, who intercepted the vehicle and imposed the tax. First of all, this second paragraph 4, this is only they have quoted the paragraph 4, subsection 3, subsection 1, section 3. They have quoted the tax act. Now, your lordship, kindly come to page 3, paragraph 5.
Yes.
Only the facts has been quoted here. Now, your lordship, kindly come to. So, for the allegations with regard to my lord, imposition of tax and additional tax, along with my lord, the imposition of fine for my lord, as without permit, vehicle as without permit, having been the without permit, when it was intercepted, because the counter signature has not been granted till that date. So they have stated that it is without permit.
So it is not a valid permit.
And they impose the tax, impose the fine thereof. Now, your lordship, one after another, I am placing in my exception, your lordship will find that at page 3,
Yes.
paragraph 6. Now, my lord, these I have specifically pleaded in my ground of appeal as well as my lord the stay applications that I will my lord annex with my writ petition. Now, my lord, GC, my lord, these your lordship kindly come to section 66. Now, may I please section 66, subsection 3, my lord, section 66, subsection 3, clause P.
You are on the Motor Vehicles Act.
My
Didi?
lord, may I?
No, no, have it here. সব বইগুলো রোজ উল্টো পাল্টা করে দেয় ট্যাক্স অ্যাক্টও দেখে রাখুন
My lord,
চটি বই না সরু বই হবে
I am on Motor Vehicles Act.
Section?
Section 66. May I place, my lord? May I hand over a book, my lord?
No, the book is there.
66 subsection 3. Now, section 66 subsection 3. Section 66 is the necessity of permit. Now, subsection 3. The provisions of subsection 1 is that provisions of subsection 1 shall not apply. Now, my lord, kindly skip over all these clauses. Now, my lord, kindly come to P. P. To any transport vehicle while proceeding empty to any place for the purpose of repair.
How do you prove that it was for
That
the
I
purpose
have
of
pleaded
repair?
in my memorandum whether they have discussed this issue and when they intercepted, well, these passengers were there. Nothing has been discussed, my lord, in the order passed by the appellate authority. Though I have taken this point in the memorandum of appeal as well as my stay petition, where these order at all, the findings where from the appellate authority come to these findings and while denying whatever I have stated in my memorandum of appeal, that has not been discussed. Maybe the other thing also there, my lord, nothing has been discussed because my lord, the appellate authority somehow, my lord, the fact finding authority. Now, my lord, the appellate authority must have to based on the basis of the facts which has been. So, my lord, this is not the writ court as your lordships refer this matter because this is the questions of facts to be dealt with. So, I have pleaded everything in my appeal, memo of appeal and my stay petition. When now your lordship kindly.
The
These para on considering the above, what is the facts?
Yes, let us hear Mr. Devra.
The other also never ever, my lord, nothing has been.
Yes, Mr. Devra.
The order passed by the Supreme Court, an appeal was referred before the appellate authority and appellate authority after considering all the pros and cons of the
Where is the consideration?
No, that is one of every word cannot be mentioned, cannot be mentioned in the order.
So
In any order.
Need not be a speaking order?
Speaking of definitely, they cannot be, if in any case, my lord, if any order passed by your lordship, I prefer an appeal. Appeal court detailing the entire things. Can it be done? Can it be done?
Where is it? Where is the consideration?
Well, this is the consideration, lordship can see 135, page 135.
There is no consideration at all. It only says the petitioner did not pay, so he has to pay. The petitioner has taken several points in the memorandum of appeal. Those points are either to be rejected or allowed. Where are those discussions?
Ground 2.
This is an absolutely cryptic and unreasoned order.
That is not there. Detail is not there, but only thing, well, main substances is there. In that case, Lordship can remand back to the appellate authority.
It has to be reconsidered. Petitioner has relied upon 66.
61 is not applicable.
1P.
61B is not applicable.
So the appellate authority should say that it is not applicable.
That has to. That has to.
Now, your lordship kindly come to my
Let it
page.
be sent back for a fresh
This
consideration.
your lordship kindly. This is the second time I have appeared, my lord, before this court. My lord, I'm challenging the validity of this order. Now, your lordship, can your lordship be remanded back to the because of no, not
This is not the second time you're coming against the appellate order.
no. This is the first time, but this appellate authority, I have exhausted the remedy. Now, can it be remanded back? My lord, I will let it.
Court, upon direction of the court, it can be done.
Lord.
What is the difficulty?
Now, your lordship, they have to. My lord, in that event, I think, my lord.
Are matters not remanded back to the benches, the courts?
My lord,
If
only
it's
one.
not a speaking order?
No, my lord, only 1 minute. May I take? My lord, I just ask this, my junior to. No, the phone. Discuss. My lord, let it be remanded back, and my lord, the only one aspect. My lord, if it is remanded back, then my lord, I should get the protection to the effect.
Protection, your vehicle has been released.
No, my lord.
The flying is vehicle.
No. That I have got in the meantime, I have got my lord, the.
So what further protection do you require?
Well, that requirement is respect of 16B, because I have already submitted the bank guarantee.
Yes.
So that has to be. I am not saying this.
They are giving undertaking within 4 weeks. They pay. They are not paying.
This
have not
law
paid.
is there, my lord. If your lordship,
Appeal is pending. Appeal will be
Appeal is
sent
pending.
for
That is why I am not disturbing you.
your lordship kindly remand it back within a specific period. Let it be
Yes,
disposed of by.
Exception used by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph. The order passed by the appellate authority / district magistrate Purbo Medinipur on 11th October 2023 is assailed in the writ petition. Stop. Paragraph. Learned counsel for the petitioner submits that the issues raised by the petitioner in the memorandum of appeal as well as the stay application submitted before the appellate authority were not taken into consideration while disposing of the appeal. Stop. According to the petitioner, he is entitled to exemption under section 60
3P. 66 subsection 3 clause P.
66 3
P.
small p of the Motor Vehicles Act 1988, which is also stated by him in the memorandum of appeal. Paragraph. It appears from the order impugned that the issues raised by the petitioner in the memorandum of appeal have not been considered by the authority in dealing with the appeal. Stop. The order impugned only records that the petitioner was flying the vehicle without a valid permit, for which tax and additional tax due have been assessed and directed to be paid. Stop.
Memo of appeal is state.
It is needless to add that the order is bereft of any reasoning. Paragraph in view of the above, this court is inclined to hold that the matter be remanded back to the appellate authority for reconsideration. Paragraph. The order impugned dated 11th October 2023 is accordingly set aside. Paragraph. The appellate authority, being the
Respondent koto? The respondent number.
fourth respondent here in comma, is directed to revisit the issue.
That is fourth. Right, appellate authority.
Upon consideration of the grounds taken by the petitioner in the memorandum of appeal and pass a reasoned and speaking order upon granting reasonable opportunity of hearing to the parties, comma, within 1 month, within 1 month from the date of communication of this order, comma, in accordance with law. Disposed of which action?
No, whether after the communications within the after communications of the order. Yes. Or after
It's an appellate order, it will be uploaded. An appellate order need not be communicated separately.
but this order has to be communicated.
Yes, within 1 month from the communication date of
From the date of
communication. Rajan, within 1 month from the date of communication of the order will answer.
Huh?
Next.
I'm
for the state respondent also. May it please your lordship, my lord, this is my application under Article 226. But may I file the affidavit of service? My lord, all the respondents have been served, and the private respondents have also been served. That communication has come from the post. Yes, ma'am.
You are appearing for the state.
State, yes, lordship.
Where is the service on the private respondents?
My lord, on page 13. From the department, it has been said that the addressees have received. My lord, on the next page, the postal receipts are mentioned.
Very good. Yes.
My lord, I am a finance company. The petitioner is a finance company. We had given a financial assistance to the private respondents for purchase of a vehicle. They paid some installments and then they later defaulted. Upon their default, I served them a notice under Section 21 of the Arbitration Act. They appear in the arbitration. Their presence is recorded. After that, my lord, I am entitled to repossess the vehicle in terms of the agreement. I carry that out in January 2022. And thereafter, as per Section 51, subsection 5 of the Motor Vehicles Act, I carry out all the compliances. My lord, today I am before your lordship because I am aggrieved by the respondent number 2, the regional transport officer, not taking any steps with respect to registration. And that is something that I am entitled to under Section 51, subsection 5. My lord, may I take your lordships through the documents? Firstly, the agreement is at page 18.
Yes.
Would your lordship like to see the clauses or should I go on to the representations, my lord?
The representation there.
Yes, my lord, the document of repossession. These are the compliances that are required under Section 51(5), my lord. Page 30 is a letter dated 3rd January 2022. I'm sorry, my lord. This is the repossession of the vehicle. The representation is right after. Repossession date is, my lord, 3rd January 2022. Lordship will find that on the right-hand side,
Right.
at the top. Thereafter, my lord, we write to the officer in charge, page 31, of the Uday Narayanpur police station in Howrah. that we have repossessed this vehicle. This is a day after, my lord, 4th January. And the same is communicated to the private respondents at page 32. Thereafter, my lord, the further compliances that are required. Your lordship is pleased to take page 33. To the regional transport officer, we write that we have repossessed the vehicle on 3rd January. It is lying in such and such place in our possession. Kindly cancel the registration and issue a fresh registration in my name. The representation thereafter is, my lord, on page 40, 25th August 2023. This is the second representation. It refers to the first one in its reference, my lord, 7th February. And this is the second one, saying the same thing, that we have taken possession of it and the forms that are required have been duly filled up by us.
Then accept E5 bills.
And my lords, after that is the arbitration award. I should show your lordship the stoppage report form and the form 36, which are necessary, page 35 and page 38. Thirty-five is the stoppage report form. It is in my possession. I am the financer.
Yes.
And my lord, page 38 is form 36 for fresh certificate of registration. My lord, in such circumstances, my lord, I am humbly praying that a fresh registration be granted in my favor and the existing registration be cancelled. And my lords, if I may, though I don't know if it will be necessary, my lord, if I was going through certain judgments, my lord, and an interesting point has come up, although this is very settled and there's no ambiguity here. But my lord, even in the off chance that my learned friends argue that refusal to give back the documents from the existing owner, that refusal, my lord, is not required for me. I am not required to satisfy your lordship that
Have you
they
made
have.
a case of refusal?
No, my lord. But this is just an extra thing that I came up, my lord. If I may hand up a division bench judgment of the Allahabad High
Let's
Court.
first hear the statement.
Very well.
No, my lord, let it be considered by the respondent number 2. Auction purchaser. Well, auction purchaser has no right.
I am the financer.
Financer.
Financer has right. Financer has right. Financer has right.
Let it be done in terms of 51(5).
We considered in accordance with law, it's acceptable. Because either, I don't know, man, either auction purchaser cannot be direct. Financer is.
He's the financer.
Financer is the.
Let
He's
it
a
be
lawful
considered within maybe 2 weeks.
Weeks cannot be.
I don't, but for my lords, if I may urge your lordships that I am entitled as per 51(5). Of course, the state authorities will consider the same representations that I have to make. But section 51(5) entitles me that the moment I have possession,
Yes.
and the moment I.
Notice to the registered owner.
Yes, my lord.
Is the owner. Financer is the owner of it.
Yes, yes.
The moment I take possession, my lord, I am entitled to get it back. I'm praying for directions in terms of prayer D and prayer E on page 15 and 16.
Prayer
D and prayer E, my lord. Page 15 and page 16.
October 27 is your first representation.
Yes, my lord.
Yes, your lord.
27th October 2022. Then, my lord.
November.
Yes, my lord. But the ones that are annexed are 27th October 22, 7th February 23, and 25th August 23.
Affidavit of service. Paragraph, none appears for the private respondents despite service. Paragraph. The petitioners are the financiers who provided credit facility to the private respondents for purchase of an Ashok Leyland truck to the tune of rupees 12,60,000.
12,60,000.
12 lakhs, 12, 60, 000. Stop. Thousand Vide loan agreement চলছে ওর সাথে Vide loan agreement executed on July 20, 2016. Stop. The private respondents defaulted in paying the dues from August 17.
August 2021.
August 17, 2021. For which an arbitration proceeding was initiated and notice under section 21 of the Arbitration and Conciliation Act, 1996, served upon the private respondents on September 27, 2021. Stop. The vehicle was repossessed by the petitioners on January 3, 2022. Stop. The petitioners applied before the second respondent. Second respondent requesting cancellation of the registration in favor of the private respondents and issuance of fresh registration certificate in their favor in terms of section 51 within bracket 5 of the Motor Vehicles Act 1988. Stop. Several representations made by the petitioners in this regard before the second respondent fell on deaf ears. Stop. The petitioners seek a direction upon the second respondent to consider their representations and issue fresh registration certificate in their favor upon cancellation of the earlier certificate issued in favor of the private respondents. Paragraph. Learned Counsel for the state respondents submits that the second respondent be directed to deal with the representations submitted by the petitioners in accordance with law. Paragraph. In view of the above, this court is inclined to hold that since the vehicle has been repossessed by the petitioners due to non-payment of installments by the private respondents, the concerned authority, being the second respondent herein, be directed to consider the representations submitted by the petitioners within 4 weeks from the date of communication of this order and take a decision in terms of section 51(5) of the Motor Vehicles Act 1988. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof.
I'm grateful, my lord.
Next.
Grateful, my lord.
Lord, I appear for the petition of Lord.
Service complete?
Lord, for respondent number 3 and 4 means, Lord, the service has been returned back.
Return?
Back.
What does it say?
But I have received,
Out for delivery, it is not served.
my Lord, I have received it subsequently. My Lord, on the later date, I have received the,
What have you received?
my Lord, the
The
service.
service.
Yes, my Lord,
So,
I have received. Shall I,
where is the affidavit?
Lord, I shall
Please
come.
come back after service. Since service upon the private respondents is not complete, comma, let the matter stand over till 27th March.
At 8:30, I am back to appear on the petition. Your Lordship, last occasion, was pleased to direct my learned senior friend to take instruction. Your Lordship, can you remember that, my Lord, this is a, my Lord, regarding, my Lord, a auto rickshaw permit. And, my Lord, your Lordship was pleased to direct my learned senior friend to take instruction. Whether, my Lord, I am not issuing.
Say that you will not use
Yes,
the
yes.
conversation. Yes.
And,
That is my instruction, my lordship. Kindly see, my lord. Only,
my Lord, let a copy be given to me.
yes, yes. You can do one also.
His suggestion has not been considered at all. He says he'll not go to Chandanagar station, he'll only go there for dropping.
Lordship, kindly see, my lord. Inquiry report, distance, sir. Third paragraph, as per office record, 58 autos of several routes are already plying from Chandanagar railway station west side, out of which 44 autos are plying almost in the same alignment. Issuance of further auto rickshaw permit will lead to increased traffic congestion in that area badly and will decline road safety. So, however, in terms of order, transport department, so, FME on the so, and subsequent resolution RTA board the application for new permit auto rickshaw. The petitioner may apply route number 53 auto from Nosipur to Boichipata, Nosipur, which is nearer to the route.
You have not considered the suggestion made by the petitioner in the earlier order. It is recorded in the earlier order. The petitioner says he will not use Chandanagar for parking. Here you have said there is no parking spaces in Chandanagar. He doesn't need it. It should be, the report should be in terms of the court's order, Mr. Debra.
Well, difficulty is there, but here is Chandanagar, there is a very difficult position.
He is not asking for Chandanagar parking at all. That is what
Touching Chandanagar is very dangerous, madam. Those who are
dangerous. I'll allow the writ petition then.
Then lordship can pass order.
Yes.
Well,
only indicate that he is not stopping.
Yes,
there,
yes.
parking.
I'm already dropping. Yes.
In the writ petition. Her learned counsels for the parties. The petitioner has prayed for issuance of auto rickshaw permit What is the resolution of 24th January?
What resolution of
24th January, prayer B.
prayer below? This is the impugn resolution. They have taken the point of congestion and the parking place. That's why I am submitting before Lordship. I am not. Page
Resolution
60.
Your prayer is issuance of permit from
That is my application. Application is I'm showing before Lordship, my lord, application is,
57,
yes, my lord, page 42,
your application?
page 42, annexure P12.
Even. For the route, Chandannagar railway station, west side
To Nosipur railway
to
station.
Nosipur railway station. Stop. The petitioner's request was turned down by the authority on the ground
That is my last paragraph of page
that
60.
the application contravenes the provision of clause 6 of the notification dated January 29, 2010 of the Transport Department, Government of West Bengal, since there is no parking space in and around Chandannagar railway station, and also, parking of existing autos has already created huge congestion in the said area. Stop. As recorded in the order passed on 21st February 2024, as the noted sentence. The petitioner undertakes to ply the auto rickshaw from Nasipur railway station and use Chandannagar railway station only for dropping the passengers. The petitioner further undertakes not to use Chandannagar railway station for parking the auto. He intends to ply the auto in a remote area under the panchayat for benefit of people in and around Nasipur area. Paragraph. A report has been submitted by the respondents today, which demonstrates that there is no parking space in and around Chandannagar railway station, and several autos are already plying from Chandannagar railway station west side. Stop. It is most unfortunate that this is an irresponsible report without taking into consideration the observation made by this court in the earlier order, as well as the undertaking given by the petitioner in this regard. Stop. Since the paragraph. The report is merely a reiteration of the observation made in the order impugned. Paragraph. Since the petitioner undertakes to ply his auto rickshaw from Nasipur railway station to
Chandannagar railway station for only dropping the passengers.
No, what will be your route?
Nosipur railway station to Chandannagar railway station.
From Nasipur railway station and use Chandannagar railway
Yes,
station only for dropping the passengers. And also, in view of the undertaking given by the petitioner, that he shall not use Chandannagar railway station for parking his auto, the petitioner's prayer is required to be allowed. For the benefit of the commuters in and around Nasipur area. Stop. It is also recorded that the petitioner undertakes to ply the auto in the route covering a remote area under the panchayat. Paragraph. The order impugned dated 24th January 2023 is accordingly set aside. Paragraph. The
I am not disturbing.
Yes.
He has to mention some places where the
that is what exactly I asked, the route.
Route for this my application.
You say panchayat area, remote area. What are the areas?
Area mentioned in the application itself. You also kindly see page number 12. Route is already mentioned. Route number 45 auto. This is recorded route of them. And I am your lordship kindly see via your lordship it is there via Shetpur More, New Digha More, Nandohat Tola it is recorded in the application itself page 42. This is a route recorded to them this is a route number 45 auto I have mentioned via I am
observe that the bundle number registration is not.
Chandranagar, he used only to drop.
Only drop. Yes, I'm saying.
In terms of the undertaking.
I'm saying. No, I'm terminating before the Nosipur railway station. I'm not terminating in the Chandranagar railway station.
Yes. Paragraph. Korun. The petitioner is allowed to ply his auto rickshaw in route 45.
Yes, route 45 auto.
45.
Auto.
In terms of the undertaking given by him before this court. Yes, Mr. Debra. In terms of the undertaking given by him.
Yes.
Yes. That was inserted in the route permit also.
Yes.
This undertaking also inserted in the permit.
Yes, my lord. But I will use.
Permit has not been granted as yet.
No. At the time of issuance of permit, that has to be authority.
Yes.
Has to be pointed out, endorsing.
Paragraph. The concerned authority being the board.
The respondent number 3.
Secretary will issue.
Yes.
Mr. Debra, secretary will issue.
You done, well, a board has to be board.
The second respondent is directed to issue permit in favor of the petitioner. In route number 45, in terms of the undertaking given by the petitioner before this court. Before this court, within 4 weeks. Within 4 weeks from the.
Board will take decision regarding grant of permit.
No, they will grant permit.
Yes, your lordship, your lordship allowed.
Issuance authority is secretary.
Secretary, yes, it's not 3.
Decide the
the issue already decided by the honorable court.
Decision is taken by the court. What a third respondent court.
Taken by the RTA board regarding this issue. On a next matter, this issue also what the notice to RTA note.
No, because the decision is taken by the court. Upon setting aside,
that is all.
Upon setting aside the decision of the board.
The position of law.
Yes, the board's decision has been set aside. The court has taken a fresh decision. So now a permit will be issued.
Respondent number 3, my lord.
Three, third respondent. Bolo. Within 4 weeks from the date of communication of this order, subject to the petitioner complying with all other
My lord.
formalities
Deep low, please.
disposed of, etc. Next.
May it please your lordship, my lord, I am for the petition, my lord. This is my affidavit of service. But this is a matter in relating to where, my lord, the petitioner company has been manufacturing e-rickshaws battery led. My lord, there are various judgments which has been passed by your lordship, my lord. I am relying upon your lordship's judgment also. My lord, Rule 126 of the. Oh, sorry. I'm extremely sorry.
Yes.
I thought it was my matter, my lord.
It's not your matter.
Mine is 849. Sorry.
Please, Miss File Mitra is.
No, sorry.
You're appearing.
I'm sorry.
The intervention application. See the other can 1 of 24. Oh, it is sorry, yes, it's appearing. It's appearing. Yes. This is e-rickshaw matter. Yes, Lord.
I have not been added as.
Let it be taken up together. Let him be added as a party. I don't think you have any objection.
There is some intervening points to that because
Do you have any objection to the said application? Very well. Please make your submission. Do you want to use an opposition to this?
My lord?
Lordship, I want to file the opposition, but before that, I want to submit a little point.
With regard to the application first, not the writ petition. Since there is an application for intervention, this has to be disposed of first, right?
Right, Lordship, but there is no question of intervention in this matter, Lordship.
Do you want to come up with an opposition or are you ready for the submission? Are you ready for the hearing? You don't want to use an opposition to the application.
I want to prefer the opposition. Before that, I want to
file an opposition to the application.
May I clear with the submission of my junior? Yes, let him submit first. He is the petition of the
Do you
candidate.
want to file an affidavit in opposition?
No,
against the application? That
no,
is what I'm
not right
asking.
now. After accepting what is his case, he should be first in respect of the can application. He should be submit first. But we have got some objection
I think
about
I'm
the
not
matter.
making myself clear. He will make his submission first, absolutely.
No, this application, can application is no more added as a party here because we want to hear out the matter first. Because some points is there hesitated by my learned friend. It is not applicable. He is not in a position to add it in this way, only to detecting the
Want
matter.
to make oral submission? I'm asking this for the 5th time, I think. Do you want to make oral objection against the application or do you want to come up with an affidavit in opposition against the application?
So we want to
That is my
file.
question.
We want to file evidence in opposition relating to this application.
Against the can?
Yes, in respect of the
That
can.
is exactly what I'm asking.
In respect of the can application.
Let them come back with the affidavit then.
But prior to this, my lord, we have this application is not maintainable at all. This is the first time. Let the question comes. If the application is please if the application is allowed in this
I have
chance.
asked a very simple question. Are you ready for the hearing? Or do you want to file an affidavit?
Ready for hearing of the can application.
Can application, or do you want to file an affidavit in opposition against the can application? If you want to file an affidavit, I will not spend further time on this today. That is my simple question.
Yes,
I'm
but
asking for the 10th time, sir.
my lord,
Please.
prior to submission of the affidavit of opposition, I like to hear out the matter because the can application is not maintainable.
This can application is not mentioned.
This point in your affidavit in opposition.
So let it be.
Learned counsel for the petitioner seeks to use an affidavit in opposition
Admissible now.
to the application being can 1 of 2024. It a can 1 of 2024 এই order করবে। Paragraph within 1 week opposition within 1 week sufficient. Paragraph affidavit in opposition be filed within 1 week from date. Paragraph affidavit in reply comma if any comma be filed within a week thereafter. Paragraph let the matter appear under the same heading on 10th April. Next.
But I am for the petitioner.
Yes.
Well, Mr. Debra is appearing for the state, my lord. But kindly come to page 16 straightway.
60.
16. Prayer for accepting necessary application for stage carriage permit and fees thereupon on route such and such against one vacancy arising out of cancellation of permit vite number such and such against vehicle number ato as per RTA board resolution dated 10/10/23 vite agenda number 10. My lord,
has been declared.
yes, my lord. Not declared. My lord, they have RTA has cancelled the permit of one vacancy. My lord, let them accept my application and consider the same. It is, my lord, it is a notified route. Vacancy arises. My lord, kindly come to page 14. 13 and 14.
Yes, but you have to apply after declaration of vacancy.
My lord, there is no provision for declaration of vacancy. My lord, in the
There
notified
has to be a notification.
in the notified route, when there is a vacancy, anyone can apply for permit
How
and
have you learned about the vacancy? It is an internal decision of the board.
yes, my lord, as because my lord, the RTA cancel one permit. My lord, kindly come to page 14. The RTA board discussed the matter and decided to cancel the restoration of permit height number such and such, a vehicle number bearing number such and such of the route number at such and such. My lord, this is the notification. This is the resolution passed by the RTA board.
So this resolution is made public
Yes.
in the website.
Yes. Yes, my lord. In the website. My lord, this is the this is one of such notified route where my lord, there is no question of apprehension, my lord.
What is the procedure?
My lord, may I submit? My lord, it's not that, my lord. My lord,
Application will be considered upon publication of the vacancy.
my lord, the RTA will sit tight over the matter, my lord. They will not declare vacancy. My lord, in terms of the resolution passed by the RTA, they have already cancelled one permit. This is a notified route. When vacancy arises, my lord, anyone can apply for the same.
Let it be considered. I personally feel it is premature.
My lord, how, my lord? My lord,
Let it be considered.
this is the resolution of the RTA board, my lord.
Mr. Devra, let it be considered. No, I'll not on merits at all. Let it be considered.
My lord, as per resolution, my lord, the petitioner came to the knowledge that there is a vacancy, and my lord, on the basis of such resolution, the petitioner submitted his representation.
But there is no rule of first come, first serve.
No, my lord, that is true, my lord. My submission is as and when, my lord, the petitioner came to know that there is a vacancy arising out of the resolution passed by the RTA board, the petitioner submitted one representation to accept his application and consider the same in accordance with law.
This will be rejected as premature, sir. Let them declare the vacancy first.
There is
In all cases, what we find is upon arising of a vacancy, it is declared. in public domain, then applications are invited.
But already notification is there by declaring the fixed strength of a notified route.
Maybe.
When there is a vacancy.
That is the maximum, that is the root strength.
Yes, my lord, when vacancy arises, anyone can buy.
No, it cannot be done automatically. The authority has to declare that we'll take another.
There is no.
Fleet strength is the maximum number of vehicles that are allowed.
To the best of my knowledge, there is no such provision.
But in all the matters that I am dealing with, I find there is a declaration that there is a vacancy, you can apply.
Kindly adjourn this matter, my lord. I shall place some judgment of my lord. My lord, where my lord, please to direct the authority to accept such application within 15 days and to consider. My lord, my only prayer is, my lord, accept my application and consider the same. This is my prayer. My lord, kindly come to page 16. Prayer for accepting necessary application.
Let it be considered this later. The petitioner seeks. Yes. Hearing all concerned. Seeks consideration of his application for issuance of stage carriage permit.
Not consideration, not acceptance of my application.
Submitted on 17 January 2024. Upon arising of one vacancy in the route due to cancellation of a permit by the RTA board by a resolution dated
10/10/2020. Page 12.
dated 10th October 2023. Paragraph. Learned counsel for the respondents submits that. Who will consider? The board.
Number 2, my lord.
The board. The second respondent be directed to consider the application in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the application submitted by the petitioner dated such and such. When I say considered, how can it be considered without acceptance? When I say consider the application,
First, my lord, yes. RTA board will watch.
in view of the above, the petition is disposed of. Directing the third respondent to accept the application.
Yes.
Third respondent to accept the application submitted by the petitioner dated such and such upon the petitioner depositing requisite fees within 2 weeks. Acceptance. Mr. Debra, acceptance within 2 weeks. Within 2 weeks from date. Stop. Upon acceptance of the same, the second respondent is directed to consider and dispose of the same within 8 weeks. Within 8 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Next. Who is appearing for the private respondents? No, there are two private respondents also. Item on hold. Addressee cannot be located in the first one. One is served, the other one is not served. Item returned, it is delivered to the sender. You have to serve and come back. One is received, the second one is not received. It is delivered to the sender, not the addressee. Page 7.
My complaint is right. Out of the 40 permit holder, our allegation against the whole permit holder. They are trying the legal violation of the good condition. If their permit is sent, we have objection. The route number 38, after acquisition, they inform me, director, vice chairman, also the advocate of record of the.
I cannot also make out to whom you have served. The president, which president, route number and all are not stated. Yes. Where is it stated? Where is it stated 239 is served? Where? Please show me from the affidavit of service.
They inform me, they have received the bill.
One has received, one has not received. I do not know, I can't make out. The first one is received, the second one is not received. One is to the sender, not the addressee. It could not be delivered, so it has been sent back to you.
Yeah. The delivered on the but sender that be delivered.
Sender is you.
But actually, we have received and inform me.
And it can't be made out who has received and who has not received. Both president, route numbers are not stated. How do I understand to whom you have served? There should be a proper service. This becomes a ground for appeal actually, otherwise. Please serve and come back. Since service upon the private respondents is not complete, comma, let the matter stand over till 2nd April. Oh. Yes, next matter. This petitioner, Mr. Service.
I have some.
Private respondent, who is appearing? You are for the petitioner.
I'm for the petitioner. Mr.
Right.
Sina is the private respondent. I think she is appearing for Mr. Sina.
Yes.
But I have no relief claim.
You have no objection.
But this is a case, my lord, where my lord, the petitioner purchased a three-wheeled auto.
The petition,
Three-wheeled, well, this is a case where the petitioner purchased a three-wheeled eco-friendly vehicle. Number he purchased from the dealer. Number dealer issued invoice and the all other requirement for registration of the said e-rickshaw. That all documents I have annexed with that is page 15 to 17. I not he submitted these documents with the registering authority for registration. Now under the registration, the authority kept the matter pending. Now that he moved before this honorable court. That as page 23, the order passed. October 2023. Now this order directing the authority, and your lordship will find that petitioner purchased an electric operated e-rickshaw and replaced this vehicle for registration. The registering authority at Howrah. The registering authority refused to register the vehicle at once and had this then pending. The grievances of the petitioner is that for want of registration, he is not in a position to ply the said rickshaw commercially and thereby he is not considered. The annex there is there, the that your lordship will find the annexure, page 21.
your prayer has been turned down.
There, my prayer has been turned down. One of the aspects is this section 41. Section 41. Act. Proviso.
The order is at page 11, page 20.
That is at before that. Section 41 of the Act.
Yes.
Now, your lordship, section 41, an application by or on behalf of the owner of a motor vehicle for registration. Now, your lordship, kindly come to under the second proviso of section 41, subsection 1, second proviso.
Yes.
Provided further that in case of a new motor vehicle, the application for registration in the state shall be made by the dealer of such motor vehicle if the new motor vehicle is being registered in the same state in which the dealer is situated. Now, that means that through dealer. I will also kindly come to page 27. The registration now is made through online mode. And my dealer, your lordship will find my dealer through online made this application and deposited the fees thereof. This is a disclaimer your lordship will find. Your lordship will find name of the dealer. And a column, the serial number, dealer's name and address. Ma Kalpuna Enterprise, Eastern Bypass, asking for more serial number. Your lordship will find.
Yes.
Now, my dealer is. Now, your lordship also will find another page, page 21.
Yes.
This is also a direction issued upon the regional transport officers all to register the vehicle. And where your lordship will find the name of Ma Kalpuna Enterprise. the paragraph in compliance of the order of the Honorable High Court, Kolkata, so and so, so and so.
So it's a blanket order
This has been given in respect.
allowing registration of all vehicles
All vehicle,
of
but
this
this is
particular
in
dealer.
particular, your lordship will find that in paragraph, in compliance of the order of the Honorable High Court, Kolkata, so and so, so and so, basically Transport Department, Government of West Bengal has instructed to
Should be
take
manufactured by Mark Alpona, yes.
yes, in respect of Mark. Then what happened? They considered and rejected the prayer that your lordship will find at page 25, one of the memo by which they have communicated the reasons. Page 26.
Is there any provision for lottery in the Motor Vehicles Act?
Why not?
Is there any provision for lottery?
Neither is there. Even then, your lordship will find 1, 2, 3. And whereas, nowadays it is started whereas this recital, but I don't know why. Whereas the route number 21 is a notified route with a fleet strength of 60, which was fixed by the RTA in its board meeting data so and so. I have not, so far my knowledge goes, in the Act itself, there is no provisions of fixing the fleet strength. First of all, in respect of electric operated the rickshaws, there is a provisions that has been exempted from granting the permit. There only requirement of registration. Now that has been here, they have stated what is the route 21 is a notified route. That assuming but not admitting. Section 74 subsection 3A is a providing clause by which the state government may, if so directed by the central government, may fix the number of a particular class of contract carriages. There, the exemption in respect of the e-rickshaws are there. By the amendments of the new act, where the e-rickshaw has been given, and e-carts also. Now, second point is that that notifications never ever. Now, your lordship kindly come to the stand they have taken. That is at page. The resolution. It starts from the resolution. Page 31, resolution 11. Page 20. Page 28. A copy of the resolution I have annexed.
Page
28. Of the resolution of the RTA meeting held on 15th of February 2022 at so and so and so. There your lordship will find. Now your lordship will find page 31. It's a continuous resolution, agenda plus resolution, agenda plus resolution. Now on page 31. Now your lordship will find page 31. Agenda number 11, then resolution. Agenda to discuss about the application received from so and so, General Secretary, so and so, regarding issuance of offer letter to purchase e-rickshaw. Now the resolution. RTA discussed the matter and found that the e-rickshaw is exempted from any permit. No offer letter is required to purchase the vehicle. Registration will be allowed as per the directions mentioned in the order to so and so. Now this resolution adopted subsequent to your lordship kindly see that their decision at page 26 refer to our notification issued according to them. This is alleged notifications because this assuming that there is a notification. That notification issued on 26th of February 2018. That is at page 26. Whereas the route number 21 is notified route with the free strength of 60, which was fixed by the RTA in its board meeting so and so 26th of February 2018. But subsequent to that, this resolution adopted on 15th of February 2022. There they hold that e-rickshaws need not be required to any offer letter. The offer letter relates to grant of permit. That your lordship will find at page 11. Page 31, agenda 11, then resolution 11. RTA discussed the matter and found that the e-rickshaw is exempted from any party.
Yes.
Now, this is my submissions as well as the and so far this resolution is concerned, they have taken these issues that the lottery last. But your lordship now, whereas motor vehicles office throughout this state, West Bengal, it has been last part. Now, therefore, heard the petitioners sympathetically and considering
This is a subsequent resolution which is applicable in your case. This is a subsequent resolution.
the resolution.
It's a 2022 resolution.
Yes, 2022 resolution. But they referred this resolution. Your lordship kindly come to my resolution when they have adopted this resolution. This resolution adopted.
They say 2018.
There they said 2018. Subsequently, it is found that the requirement of permit is no requirement of permit in respect of offer letter to purchase a vehicle because of these e-rickshaws and e-carts are exempted from issue of permit.
Here they're talking about fleet strength, not offer
That
letter.
really when it is if the route is notified under section 74(3)(a) in respect of contract carriage permit.
And they say it is a notified route.
They say it is a notified route and notified by the regional transport. Lordship kindly comes. Is it a gazette notification? Is it a notification under section 74(3)(a)? Your Lordship kindly, this is a resolution adopted by the board.
The petitioner doesn't possess a driving license also. That is one of the grounds taken.
Driving license. But I shall show the e-rickshaw. So far as not the auto. E-rickshaws need not be, that is there, I shall produce.
Not necessary.
But I shall produce. There is a provision, it need not be required to a driving license in respect of e-rickshaw. And your lordship kindly come to the last, that lottery. Where from these comes to the
lottery, let the authority explain.
All, the notifications also. Whether these notifications by which they limit the number of. Let them produce. Where is that notification? Notifications must be in the official gazette and that too by the government. Your lordship kindly come to page, the section 74, subsection 3. Assuming.
Yes.
Assuming this is a notification, then there must be 74(3)(a). Now, the first line is in respect of grant of contract carriage. There the permit, contract carriage permit. Now, if in respect of electric operated, battery operated rickshaws and the cars are exempted from the category of section 66. Then the 74 need not be required to, and subsection 3 also there too, because that is the rest, that is the subsection 3, that the restriction by the state government, Now, that they are saying this is a notification. Where from they conferred the power, but that I have taken. Where from the Regional Transport Authority derived the power, a statutory power, by which they issued a notification fixing the strength of, the grant of registration of a particular type of vehicle which called the battery operated e-rickshaw.
Let the state respond to this.
Fine.
I think you have to come back some other day. Mr. Sen, do you want to come back with a report or you will make your oral submissions? It is your choice because there are several issues which are being raised by the petitioner.
Sure. Sure. Huh? Petition से बकरे चला भी तो कम से नहीं
As my lord, are applicable based on people is only thing is this by way of the government implement the fund. Other no other all other in respect of this commission to do public everything are allowed except the part.
Even besides that, there is a question of road fleet strength.
Now, my lord, there is no question of tracking farming. They need the not come. The whether it should come under section 748, that is contact area, or 723 small a, that is my lord, state care. Because unless the vehicle are being this as contact area or state care, that is on the basis of the farming. Otherwise, my support the big buses and other all are on the bus. And so for these type of vehicles and other, these are all exempted, right? Now, these vehicles, yes, but there are similar that first of all, the applicant of this is not the registration. We must have a license. We must have the policy. It is not I shall not.
So there is no fixed fleet strength.
Now, I'm coming to that. Now, again,
which one the guy asked? He's available. What is the name to apply?
Because unlike specialized contract, here there is no property. If that is not, then it does not come within section 7.3 or section 7.6. Then what should be? The meaning may be that all the registered vehicles may say that from Howrah station to Sealdah, each of it look very area. So we shall apply on this state. This cannot be allowed. What in a particular area, it might not be more than 100 units registered. I'm not talking about unregistered or illegal. Even after registration, if 100 say that let us fly on this state, this is probably.
So is there a notification?
And that is why all of this circular and your mother given to the particular registration authority. It's the route and the mother.
That notification is not there on record. Another thing, the provision for lottery.
Now the provision for lottery is there. Why not go there?
when there is no such provision, I consider one. Because when it is my lord, no already my lord, remove that my lord for several petitions, when it appears that the number of applicants outweighs the number of the my lord, the limited number of
Mr. Question.
now, there my lord is 7180. And what in case of 7180? Now the other parameters are there. What should be the parameter? And all the parameters are configured to individual circles.
Can it be lottery?
Now, I mean, they are there in the circle. I am not considering lottery. I am not considering lottery. I am on the exercise of other constitutional power. That's to how to eliminate which can consider. Also, because they are not able to say that can consider what should be the minority with the age one to lottery. A minority is not participated in the lottery proceeding. Why leaving? When after unsuccessful, because then no why not? Then why not? In case of other jurisdictions, I don't know. The ones who admitted their
You cannot challenge.
You are participating in that. That means you say that this is the authorities or so I have decided. Now after the actual behavior that is about the sanction. Then this point not at all. So after having this unsuccessful now we say that why so why point he has the right to raise this point at this in this matter.
So will you submit a report or will your oral submission be sufficient? Because I think with regard to the fleet strength and all, you need to file the notification. Several points have been taken in rejecting his application, but the points have not been really clarified. There should be some provision on the basis of which these rejections were made. So the other points should suffice.
Other point is about the place of the things. There is no provision.
Driving license.
Number two, he has no answer to say that the application has not been made in proper cross in a proper mode.
That is also one of the grounds.
He has no answer to be. If that is the matter, if I go to the root of the matter, then with regard to your picture of application, it is not in proper form. If it is not in proper form, not in proper way, then whether the entire matter is very satisfied that we ask to apply that way.
In a different route.
No, I shall come from
Third, learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on 22nd April. Learned counsel for the respondents. The respondents are directed to place the relevant circulars / notifications by way of an affidavit, which has to come on record by way of an affidavit on the adjourned date.
Only one indulgence, my lord. Let my lord amendment to serve the advance copy so that I can take the recourse of that and I because this will not take the time another day.
Yes, hearing matters.
My lord, in this matter, I appear for the petitioner. On the last occasion, my lord had been pleased to pass an order granting us liberty to take an exception to the report, as also to go and take inspection of the goods which they say are still lying. My lord, I shall be very candid, my lord. Proper and adequate instructions did not come in. We just need extension of a fortnight's time, my lord, to carry out the last order.
Petitioners seek exception, seek extension of time to use the exception to the report as sought and take inspection of the goods in terms of the order passed on 6th February 2024. Paragraph, who is appearing for the respondents? You are appearing? Paragraph, let the matter appear under the same heading on 5th April. Should be
Very well.
sufficient.
Grateful, by.
5th April. Next. Petitioner,
Lordship, petitioner's clerk requested me to take adjournment for the day on this matter.
on prayer of the petitioner, the matter is adjourned. Prayer of petitioners. Paragraph, let the matter appear under the same heading on 9th April.
My lord, I am before the petitioner, my lord. I am led by Mr. Saptangshu Basu. My lord, will kindly give me a short passover, my lord. He's,
Not possible in this court.
my lord, then kindly take it up on Tuesday, then, my lord.
Have to grant it. On prayer of the petitioner, the matter is petitioners, the matter is adjourned. Jayantu. On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd April.
Great.
Next.
Hello. Your Lordship, I have been led by Mr. Saptangshu Basu and he is on his leg at court number 15. I am praying for not today.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 5th April.
Great. Your Lordship, kindly 2nd April, if
I fixed one already on 2nd.
Great.
For the petitioner.
My lord, 860
My lord, on the previous occasion, 2-3 occasions, my lord, adjournment was sought, sometime on behalf of Mr. Shonojit Ghosh, sometime on the occasion of Mr. Mary Datta. My lord, I have served a copy of the petition upon them. It's a very short matter, my lord. Unnecessary, my lord, they are dragging this matter month after month. Affidavits are complete, my lord. I have also placed my case.
2nd April. On prayer
So
of
kindly make it the no further adjournment should be taken because two advocates
Please
are.
be ready on the next occasion. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd April 2020. Next.
The other side is
I'm appearing on the petitioner.
Yes.
Yes, this case of tomorrow matter is pending since long. So kindly,
Mr. Khan, all this while it was your adjournment. So please do not raise an objection today.
No, I never.
Petitioner seeks accommodation. You are the petitioner.
61.
Yes. 19096.
Next matter, 62.
You are not a petitioner.
No.
Who is the petitioner in this case, in this matter? Yes,
What? Next matter, mine.
Mr. Neeraj Gupta is the petitioner. Is appearing for the petitioner. You are appearing for the petitioner. Yes, ready? Oh, you have missed the brief, you said. You said private respondent? Oh, so this matter also you've missed the brief. It was allowed as a last chance, Mr. Let it be dismissed, come back on the next occasion. Several dates. This is not your case. This is the earlier case. Same submission was made right from not today only. I cannot pass. Not today. Wherever it takes us to. Because I have to dismiss. Last chance has been granted already. Next.
Next matter, I will pen on the petitioner. Please bring. Come on, only for today. Because matter was hard several times. Only for not. Because matter is since. No, very absurd. They tried to, my lord, they tried to abort this matter, like very serious matter, kindly make I've done several times.
Mr. Debra is appearing in the second, in the next one.
Well, I'm making what today only. What?
You're not appearing. He has chosen not to appear, so let him not appear. We'll deal with the matter. On the earlier occasion also, he has not appeared. The state is not represented.
But Mr. Today morning also I have talked. Well, yes, I shall agree. But today he missed a bring only on this term. Today matter will be heard. Probably can play not because matter is pending since.
I'll record that the matter will be taken up even in absence of the state respondents on the next date.
Yes.
None appears for the state respondents. Paragraph, let the matter appear under the same heading on 5th April.
Because pending message,
There are so
I made myself several times. Each and every occasion they pray for time. Only one back to next week. Next week.
Very well. 22nd March. Yes, Mr. Mukherjee, 22nd March. Paragraph, it is made clear that the matter shall be taken up for, the matter may be taken up for consideration on the adjourned date, even in absence of the state respondent. Please intimate him.
Yes, I think. I shall.
Yes.
Allowance of farming in respect of PS4, PS3. Madam, last occasion, the state took time to take instructions from the authority regarding and
My affidavits are complete, isn't it?
affidavits are completed. Several times affidavits have been.
Further instruction is not required.
The matter is that BS3, the main point is that the registration of BS3 vehicles.
You have made elaborate submissions, I find.
Yes.
Please make short points just to recapitulate.
Short points.
Only for recapitulation. Yes.
The main point was that the Green Tribunal and the Supreme Court order, which has been mentioned here, that the registration of the vehicle was stopped, and the registration of new vehicles which has not complied with BS3 norms. But here, nowhere in Supreme Court's order and in the Green Tribunal's order, the issuance of permit in respect of BS3 vehicles have been stopped.
It is only registration.
It's only the registration has been stopped, and after registration, the lifespan is 15 years. Till the 15 years is not completed, I can apply the vehicle, and on that basis, I can also receive a permit in that favor on that vehicle. That is the point. But the STA West Bengal has stopped issuing permit on the BS3 vehicles, saying that the Supreme Court's order and Green Tribunal's order that the issuance of permit on BS3 vehicles have been stopped. But nowhere the issuance of vehicle permit in BS3 vehicle has been stopped by the order of the Honorable Supreme Court and the National Green Tribunal. That is the basic point in this matter, ma'am.
Let us hear the state. Yes. Paragraph?
As per the offer letter, the year 2020 is the main 2017 offer letter was allowed the guidelines for basing and have been changed and or altered in terms of the order passed by the paragraph 4 is the hearing first by the there is also 30 days of next one is however print and terms and conditions are not submitted or any letter or action within that has all on a sudden 7th August there before these stand of after the last of opposite same and one out. An offer letter was seen. Now it is supposed to he said that that was approval of the STA board is not fair for granting permit for in spite of all the sad title of the matter, without taking any step for them. That is the judgment.
This is for sale or registration, not for grant of permit.
What are the people?
That is one issue. That is one ground.
Seriously, that people, because definitely this is the condition of the alteration of condition of the offer. That cannot be published in the you are giving that kind of observation, the access to the- that is the- in compliance with the legal I think these are not completely generally not to be applied in any application. With the people having both the offer letter was they were abstract on 29 March 2027 subsequently the further abstract while producing quite different as approved is the
How did you take a resolution? On what basis?
Yes, ma'am.
Paragraph I.
29 March.
Paragraph I.
Paragraph I आगे page number 5 आगे पे जाओ.
Not to accept any application.
There is no such
The direction is not that.
Yes, ma'am.
Direction is with respect to registration and sale. And you have stopped application for permits.
I'm also relying on the
Have you placed it in your?
Then you could pass mark one notification on public. Yes. This guideline. This is another guideline. Issue their permit.
Page 15. Where are you reading, Mr. Debra? Page?
Of a different nature. See, in such factors, there is no scope that is going to be allowed. If we come to order, they can do
2nd June. No, 16. That's the order. Revised guideline, yes.
This is the last. The registration and allied back. Is of no requirements are.
This is applicable. Interstate route. Please see the language. Will encourage placement of BS4. You cannot reject a BS3.
Yes, ma'am.
So that doesn't, you are not restricting it to BS4, isn't it? You cannot reject a BS3. You can encourage BS4. This is not Kolkata, this is inter-region.
From Shah-
Interstate.
Originating from but yeah, Satragachi bus terminus. Kolkata, but Satragachi bus terminus. In the offer letter, it is also mentioned there. Satragachi bus terminus, not entering proper Kolkata also.
So, oh.
One.
Preferably be minimum. That doesn't really restrict the authority, isn't it? Preferably is not a restriction, Mr. Devra. The cogent ground is change of alteration of yes.
Now BS3. That is not the past case.
Has to be below 15 years. That is a must.
Yes, that is a must.
And your vehicle is below 15.
My lifespan is 15 years, and my vehicle is within 15 years only.
Under BS3 cannot be.
No, there is no bar that under BSc that cannot be allowed. My vehicle is within 15 years.
And how do you explain the change of
And there is,
vehicle?
my lord, there is no bar in the ILO to change the seat to sleeper. Kindly come to page 51 of the my writ petition. But it has stated clearly that there is point number that there is no reasonable restriction to use sleeper bus in a bus for a grant of permit either in Motor Vehicles Act or in West Bengal Motor Vehicles Rules. And there is no provision in the West Bengal Motor Vehicles Tax Act for imposing tax in respect of a sleeper bus. Page 51. And so far the 30 days is concerned, kindly come to page 49 of my writ
Your
petition.
vehicle should be in conformity with the offer letter.
For that, I have made.
That will be the only reason for rejection.
Yes, and for the 30 days, kindly come to page 49, where it is clearly stated that the validity of the offer letter is extended up to 19th October 2018.
Yes. You have placed the vehicle within that.
Within that time.
So, but you have to place the vehicle in tune with the offer letter.
And for such, I have made representations.
Yes.
For such, I have made also the representation that there is no impediment.
Your representation has been turned down. That's
Yes.
before this court, isn't it?
I am before this court because they have rejected to issue offer letter in BS3. First of all, they have rejected to issue offer letter or issue grant permit in respect of BS3 vehicles.
Where is the rejection order? Okay, 8081, I think, is the rejection.
Page 80, meeting dated 29 January 2021.
Yes.
And the operating portion is 81. MD Arif Hussain and Javed Ali found absent on call. Learned advocate appeared on behalf of them. Their matter was discussed in detail, and finally, members of STA West Bengal decided to reject the prayer of the replacement of vehicle as well as reject his application for grant of permit, which was allowed by STA in its meeting dated such and such, because permit with BS3 compliant norm vehicle is already restricted. And also on the ground that he has failed to obtain permit since long. However, he has the liberty to apply fresh.
This ground has not been taken at all.
Yes, my lord.
In the rejection order. That the make of the vehicle was yes. 80, yes. Of the affidavit of your opposition. Page 18, 18.
Continuation of the transport vehicle.
Yes.
Business address of the owner. No vehicle less than PS4. Compliant user norms shall be allowed, subject to restriction of man. Yeah,
Howrah cannot be Kolkata metropolitan area.
Kolkata municipal area.
How can Howrah be KMA? And in the rejection order, you have not taken that point at all. That permit, that offer letter was issued in respect of seating capacity vehicles,
Yes,
and he is placing sleeper coaches. That is not in the rejection order at all.
Yes, my lord. The rejection was mainly on BS3 point.
It is only on BS3.
That is not a demand back.
Shall I do that?
My lord, then I am praying for one more extension because I was recently instructed by my senior that he will reply to Mr. Pondosa's submission.
Oh, you're asking for time in that
Time.
case?
In that case, my senior will reply to his
Please
submission.
consider this aspect.
Deeply.
Because several issues have not been taken into
Yes,
consideration.
ma'am.
The authority has to take all this into consideration, isn't it? He doesn't want to take a risk. Let his senior come.
I have not. Lord, you can take the matter on second day.
Second April. Very good. Since we have almost taken a decision, so these matters need to be considered by the
Yes,
court. Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on 2nd April.
2nd April. 63 and 64 same.
Next matter, same order.
I am applying for.
Let the same order be passed. Mr. Ghosh is in this matter also?
No, 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 no. Well, it's a very short matter, my lord.
Railways.
Railways.
Railways without Mr. Ghosh.
Ghosh appears in some matters. He's also appearing. My lord, let me cut short the matter, my lord, because time is not limited. Petitioner was one of the operator of the Indian Railways in respect of one train which commences from Shalimar to Yashwantpur. Now, my lord, an agreement to that extent was executed on 26th of 11/2020. Thereafter, my lord, petitioner operated the parcel space of 23 tons on a regular basis, and there has been no complaint whatsoever. Excellent.
You have made elaborate submissions. I have taken a note of it.
The only thing is this, my lord, the issue which is at present before your lordship is this, that I was not getting adequate free time at Yashwantpur being the terminal station. Now, my lord, at least lordship will realize one aspect that 23 ton is equivalent to consignments loaded in 6 heavy vehicles. Now, the time which they were providing me at the Yashwantpur was 20 minutes, 30 minutes, and 40 minutes, which was not at all yes, permissible to load the entire consignments. But I was making on payment. There was no latches on my part. So, my lord, I made a representation before the authority. Look, this is the difficulty we are facing in each and every occasion. So, at least give us a separate siding so that at least we can peacefully load our consignments, because what the amount which we are paying is paying for the 23 tons, and railways are realizing that amount, but it is not for 5 to 10 tons. So the facility which is being provided by the policy, my lord, it indicates that if there is a separate terminal, then it has to be given. Now, my lord, I made a representation. The railways acknowledged that issue, and railways wrote one letter to their counterpart at Southern Railway, saying that if possible, kindly arrange for a separate siding so that this problem can be addressed. Now, my lord, that problem could not be addressed by them. Now, it compelled us to suspend the operation, my lord, because as it is coming under an old policy, there is a clause, my lord, if I face any inconvenience, then I can write a letter, and by writing a letter, I can suspend the operation. Now, my lord, I approached before this Honorable High Court for redressal of my grievances. The Honorable High Court addressed my grievances. Lordship will kindly turn to the page, Honorable High Court's order at page 75, the coordinate bench order, on this particular aspect. Sir, 75. আমি শেষ করে দিই আজকে আমার পরে মক্কেল খুব প্রেসার ক্রিয়েট করছে হ্যাঁ হ্যাঁ My lord, may I, my lord, urge your lordship to kindly come to internal page 4, because the order is quite page 78, the operative portion. Yes, last paragraph, my lord. Insofar as the operation of clause 29.2 is concerned, since the railway administration has not yet decided on the dispute raised by the petitioner, either by refuting or conceding the same, it will be premature to say that the matter ought to have been referred to the arbitrator. That apart, it is well settled that mere existence of arbitration clause does not stand in the way of the High Court in exercising writ jurisdiction, Article 226 of the Constitution of India, where a patent jurisdictional error or arbitrary action has been committed by public authorities. Clause 8.8 of the agreement squarely provides that in case of dispute on part of the railway's discharge of obligations where lease contract could not be operationalized by the leaseholder or suspended by the railway in certain circumstances, like change of loading or unloading point, not providing service, not providing sufficient time for loading or other operational problems, the railway administration shall be empowered to deal with such situation as deemed fit, depending upon the merits of the case as they are doing de facto. If later on the problem is resolved by the railway, the intervening period involved in resolving such disputes of non-operationalization are of the contract or non-loading of the leaseholder due to dispute would be treated as dice non. In the present case, unfortunately, the railway authorities have not taken any steps towards resolving the issue raised by the petitioner in respect of unavailability of sufficient time for loading and other operational problems. It is incumbent upon the railway authorities to resolve the dispute immediately and to treat the period from the date when the petitioner raised the objection, that is on May 29, till the date of resolution of the dispute as dice non. Insofar as the losses allegedly suffered by the railways is concerned, it is none but the railway authorities who are to be blamed for such losses, if any, since having acknowledged the problem raised by the petitioner by way of a written communication, no action for the resolution of the same was taken at the end of the railways. In such view of the matter, WPA number such and such is allowed, thereby setting aside the communication dated June 1, 2022, whereby the petitioner was directed to start leasing operation as early as possible. Otherwise, penal action would be initiated against the petitioner. The respondent number 6 shall decide on the objection raised by the petitioner in the petitioner's communication in respect of the loading and unloading problem and ancillary operational problems as expeditiously as possible, positively within 4 weeks from date. Immediately upon such resolution, which will be taken in accordance with the law, and upon giving an opportunity of hearing to the petitioner, the respondent number 6 shall intimate the outcome of the same as well as the date of resumption of operation, giving a reasonable period for so resuming the petition. And it is made clear that the merits of the contention raised by the petitioner and are refuted by the railway authorities have not been entered into by this court, and it will be open to the respondent number 6 to decide the entire issue independently and in accordance with law without being influenced in any manner by any observations made by this court hearing. It is also made clear that the entire period from May 30, 2022 till the date of intimation of the resolution, whichever way reached to the petitioner, shall be treated as dice non in terms of clause 8.8 of the agreement between the petitioner and the railway authorities. My lord, once this honorable court directed to treat the period as dice non, so it can be safely confirmed that there was an inconvenience on my part. And that inconvenience was directed by this honorable court upon the railways to sort it out. The issue was that whether I am entitled to a free time or not of 11.6. Now, my lord, after this order was communicated, they gave us a hearing and speaking order was issued rejecting my claim by saying that, no, you will not be provided because Yashwantpur station is a congested station where there is no siding. Now, the time this speaking order was issued, my lord, prior to that, what they have not indicated that the terminal station has been changed from Yashwantpur to SRVM. Now, in the SRVM, my lord, there is a separate siding. Lordship was pleased enough. I made one supplementary affidavit on this, and Lordship was
That
pleased.
is recorded.
Yes, yes, and my lord, Lordship was pleased to, and they also used one affidavit in opposition. Lordship will kindly come to page 12 of their affidavit in opposition. Affidavit in opposition which has been affirmed because there are two affidavit in oppositions. One which has been affirmed on December 2022.
14 December.
Yes, my lord. December, date has not been mentioned here at my copy, but appears December 2022. Page
One Rajesh Kumar.
Yeah.
The affidavit is sworn by one Rajesh Kumar.
এটা আপনার রাজেশ কুমার তো আপনি যেন লিখেন yes ma'am Rajesh Kumar, page 12 of the affidavit in opposition. They used an opposition and says, my lord, page 12 paragraph 22, true fact is that if the parcel van placed in separate terminals, both, my lord has found, both originating and destination stated, then free time will be allowed for loading and unloading for 3 hours. Otherwise, party is bound to load and unload the parcel within the available time of arrival and departure of rake as per clause 11.5. So they have stated that if there is a separate terminal, she kindly mark this particular paragraph.
So now there are separate terminals.
Yes, now that they have confessed so. Ultimately, they have confessed so, which they were hiding. My lord, it appears from another affidavit in opposition.
The earlier one, 16th March.
Yes, my lord, yes. But you kindly come to page 6. Some contradictory statements have been made, but it has been, some documents has been annexed. Lordship, I am taking your lordship to page 6. That it was specifically mentioned, page 6, my lord, that it was specifically mentioned in the agreement that where there will be a separate terminal, then only 3 hours of free time shall be allowed for loading or unloading of parcels. Now, my lord, the second paragraph is contradicting to the next paragraph. Kindly come to the last paragraph of that particular page, that from the report of the Senior Divisional Commercial Manager, Bangalore, Southwestern Railway, dated 6th of March 2023, it is found that there is a separate parcel siding for loading and unloading of leased VPH at SMVM terminal and in Yashwantpur railway station. Now, my lord, that has been corroborated with another letter, which is at page 12. So, page 12 of the said opposition.
Yes.
There is a separate parcel siding for loading and unloading of parcels of leased VPH at SMVM terminal and in Yashwantpur railway station, which they were denying. From the very beginning, they were denying that we will not give because there is no separate terminal. But ultimately, they have to annex this. Because, Lordship, I have demonstrated through my supplementary affidavit, apart from me, other trains have been provided with this siding, but I have been deprived. Now, my lord, daily trains having platform turnaround with leased parcel van are not allowed for loading, unloading at parcel siding. My lord, this particular aspect, Lordship, will not found anywhere in the policy, nor in the agreement. Only the question which was asked by your lordship was whether there has been a separate terminal or not. There is a separate terminal. So, like others, I should also be allowed to get loading, unloading within 3 hours of time. What has been stated in paragraph 2 does not have the sanction of law. It is dehodes the policy. Only they have stated that, yes, we will provide you with the free time, provided there is a terminal. That has been answered in my favor. And whatever they have stated in paragraph 2, lordship will not found anywhere, either in the policy or in the agreement. They cannot deviate from their agreement. So now, my lord, my respectful submission is this impugn speaking order needs to be set aside on this score, because I have ultimately, my lord, through their own report and also through my supplementary affidavit, I have said what are the other trains which are getting the facility of platform free time. So this is my innocuous prayer. Now, my lord, for last 2 years, my lord, this parcel space is running empty because I am not being able to carry on with the business because they are not providing me, and lordship has protected me from any early termination. So I am beseeching your lordship that as there is no person who is operating the parcel space, at least I should be provided in the interim to at least continue with the operation. Because lordship coordinate by judgment, lordship is there. They have not preferred any appeal against that. The issue has been sorted out. At least some truth has been disclosed before your lordship, which they were hiding back. Now, I am only beseeching, my lord, the interim order, lordship has protected me from termination. If your lordship allows me to operate at the time being,
Since the matter is almost on the verge of completion, the interim order will be extended, but no further order will be passed.
then in that case, my lord, as because lordship, that due to time constraint, I have to cut short my submission because I have only highlighted those pages.
Cut short, you can continue.
Because the thing is this, my lord, because I have entered the agreement in 2020. 2 years I have operated with great difficulty. Lordship can realize how losses I have incurred. Now, another 1 year is left. So it is not for my fault, ultimately, for which I have suspended. That has been taken note of by this Honorable High Court, that it is the fault of the railways.
Come back on the next date, I'll consider.
Now, my lord, kindly indicate that I have completed my submission and they should not say anything contrary to what, because 2 oppositions have already been filed. And my lord will always also at least take into account my supplementary affidavit. In the supplementary affidavit, my lord, I have indicated at page 22, the trains, you kindly see this, page 20, supplementary affidavit.
Yes.
This is the, Lordship, kindly see this, 29th of July 2022,
Yes.
change of terminal. And my train is at the top, my lord. It has, the terminal has changed from Howrah to SMVB. And the speaking order, Lordship, has been passed on 16th of August 2022. Prior to that, they have changed my terminal and they have not stated anywhere in the impugn speaking order. And now they are saying that in both the places, there are separate sidings. And page 21 and 22 are the list of trains, my lord, among others, where they are providing with the sidings. The trains I have indicated, they have not denied. This is my respectful submission, my lord.
If you want to add anything to this, you can on the next date.
But a very short time may be given, my lord.
Her learned counsel for the petitioner. Paragraph, let the matter appear under the same heading for further consideration. It is
By this month, my lord.
22nd
March.
March.
Great, great.
22nd March. Paragraph, the interim order granted earlier. Oh, it's already extended to 31st. Today,
Probably by 22nd, my lord, it will be disposed.
I hope so. So I'm not extending it now.
No, need not.
31st.
Correspondence. Only not today, my lord. Only not today.
I'm not calling. Mention the matter in front of your lordship, my lord, number 19, item number 19. My senior not the mention in time. Come back tomorrow at 10:30. My lord, it's subject to correction. Okay, my lord.